advertisement melody, it was told there is one vacancy for her post, and subsequently.
Let me just check today what matters will be taken up. After completion of adjourned motion, first SLST. Yours is not in the adjourned motion list.
So in item 44, motion 1.
Second SLST 41 of the monthly salary. I'll take up SLST bundle. Yesterday it was taken up. Again tomorrow I'll take it up.
Very short matter. Any day.
Tomorrow the SLST bundle will be taken up.
But that is the motion 1.
Yes.
Motion. Yes, item 3.
Item 3, I got the information that the petitioner has settled the issue with the school and he doesn't want to proceed. But at 4 and 5, I will proceed.
4, 5. It will be adjourned, but sometimes the fee petitioner himself wrote a letter that I will not proceed with.
Yes, so what why will it be kept pending?
And 4 and 5 I am told also they also were telephone.
No, yesterday night I had a talk with my client, but they want to proceed.
So want to proceed?
3 and 5 I am for
No, 4 and 5.
4 and 5.
4 and 5.
Similar.
But I am told this is the fee already settled on 4 and 5.
Are you putting pressure on them to settle it?
No. Now the school 100 students. The school is running without any finance. How this salary will be paid to the teachers when the school.
And
They have paid plus 5,000.
School collects fees. Unaided school.
Behaving school. Paid by the school.
DA is separate, but you must be.
And there is no prior approval or after approval. The order rejecting approval has not been challenged. The salary is not.
And the teacher is seeking regularization. What?
No.
Then
Regularization has been already rejected by the DA.
what do you want now?
Let them complete first. But
What do you want?
I want quashing of my termination letter, which has been issued by the secretary in the department managing committee.
Your service is no longer required. There is no student. Who is going to pay you?
Challenge.
Who is going to pay you if you stay over there?
May I
Take
open the
instruction.
I have
Take instruction.
yesterday night when I have a talk with my client.
Who is going to pay you?
Who will pay?
School doesn't have the money.
May
I call for records in that case. Accounts.
Yes, kindly do that. I request you a lot.
How much are you collecting as fees from the tuition fees from the students per student?
Student only 100 student is now.
How much fees are you collecting?
That is not the subject matter. That I have teacher strength and student ratio. I have annexed my.
How many teachers you have now?
Student. My opposition. First name ki re?
Rajesh Pandey, serial number 3, he has been paid 2,07,000.
No, Rajesh.
Money has come. They are saying that
One-time settlement.
One-time settlement, yes. They are saying that there is only 100 students, so they don't have any money to pay as salary. One-time settlement we have paid. And this letter was issued to me not by the petitioner himself. It has been sent to me by the school.
No, petitioner himself also wrote a letter.
আমার কাছে কিছু আসে
I have a copy.
That means your client is more comfortable with the school rather than with you.
doesn't me.
No, this is the petitioner's letter.
The letter is here. Letter is here.
Both the letters are there.
Yes.
3 can be disposed of in that case.
Yes.
Legalinder, the petitioner has intimated the school that he is accepting the full and final claim settlement of rupees 2,07,431, including Provident Fund. Stop. He is not inclined to proceed with the writ petition any further. Stop. And he does not have any claim against the school. Stop. In view of the aforesaid communication made by the petitioner to the school and to the learned advocate on record for the petition, comma, there is no requirement of proceeding with the writ petition any further. Stop. The writ petition stands disposed of. The stands dismissed as not pressed. Written communication be retained with the records. Rajesh Pandey is over. Now Sanjay Singh and Nityanand Gupta.
But may I proceed with Sanjay Singh?
Yes. What to do?
Let him proceed.
All right.
This is my affidavit of service. On the last day, I have last that occasion when I have handed over one order of Justice Bhattacharya on this point, and
1 minute. Where is the opposition original?
Last occasion I have handed over.
পাওয়া গেছে? This is the copy. In the there is a note from the department which says that the original is not there.
Can you see the last order passed by your lordship?
Yes, is not ready. Department was directed to trace out the file. Now this is the note. It says that the opposition has not been filed in the
You have
department.
handed over the exactly photocopy of the opposition.
That I have.
Yes.
That I have.
But the original reaffirm, don't know whether it had been previously I have handed over or not.
In that case, he has to reaffirm.
It is not there with the records.
Reaffirm করাতে হবে।
Yes, it has to be reaffirmed and filed. তাই তো? Reconstruction করা যাবে?
Me too.
1 minute. And it can be resolved at this end so that it doesn't go back to you.
In 2022.
No, I am told that it can be reconstructed also because a serial number is there. The serial instruction, you are not required to do anything. I'll get it done. Done. শুনে নি মামলাটা? Yes.
may I start? Here the case of the petitioner is that I have been appointed as one of the English teacher in 2005. In 2005 till the date of my dismissal from service, I was discharging my duty. The order which is under challenge before your lordship is at page 53. 6th of November 2020.
Yes.
Now, I am questioning this order on two counts. First of all, the managing committee is a defunct managing committee, and the secretary of the managing committee is not empowered to issue this letter. This is number one. And number two, in the affidavit in opposition, the point taken by the school is that when the school is a private school and the managing committee is a private managing committee, the teachers, the petitioner before your lordship, who is an unapproved teacher, he is also a private individual, so writ petition doesn't lie. But to that extent, on the last day, I argued before your lordship that the managing committee is not a private managing committee. But if your lordship kindly have a look to the order passed by the board in this regard, kindly have a look to page 58. This is the order of the board in connection with the said school. Kindly have a look at the finding. Page 58. Got it? The school authority has challenged the order of the board communicating by video memo number so and so on the ground that the hearing dated so and so held by the ad hoc committee lacked quorum. But due to, I am not reading that. Thereafter, last 3 lines from top. The said managing committee. Got it? Yes. The said managing committee got extension from time to time up to 31st of October 2017. Here I pause for a moment. Who had granted the extension? The board. So the managing committee is under the board. Then, in the meantime, the school authority was asked time and again to reconstitute the managing committee, but the said authority flouted all democratic norms, have been evading managing committee election for on one pretext or other. The so-called managing committee has no locus standi to take administrative decision of the school, as its prayer for extension of the managing committee was rejected by the board in 2017. The school authority cited WPS so and so, which is still pending before the Hon'ble Court, prayed for extension of the tenure of the managing committee. It does not hold any ground that there is no interim order in the matter. Hence, to break the administrative impasse, the I, President of the so and so, comes to the decision that so and so, the DI, Kolkata, is appointed as the administrator of the school. So, but the administrator was appointed by the board. Now the school is saying before your lordship by filing this affidavit that the managing committee is a private managing committee. So the school, the board, what has found by the board is that the managing committee has no locus in 2017. The same person who was there in that point of at that point of time is at present also having the same post, and he has terminated me. So
And the administrator is still there.
But my learned friend can apprise your lordship on this. But
Page 59 was on 15th of November 2018.
yes, thereafter they questioned it. Page 60.
Your impugned order is 6th of November 2020.
Yes. But I tell you, lordship, can it turn to page 60? The school has questioned this order before this court, and this court
State the order.
granted the stay. But the latest position, I think Mr. Jana can appraise your lordship. What is the fate of this writ petition of 2018? So, but the first point which has been taken by the school, that the school managing committee is a private managing committee, is practically non-est in the eye of law. It has got the approval of the board. So, Mrs. Bhattacharya is appearing for the board. If the locus of the managing committee has not been decided, so how this managing committee can issue a letter of termination to me? This is number one. And on the last day, I have handed over a decision of Priya Chatterjee dated 26th of June 2024. Joseph ki diyechen copy ta? Acha. Tomata amar kache. Where
Yes.
Justice Bhattacharya has dealt with this issue. This is a case of Balika Shikha Shodhan, another DA school, where the teacher was terminated.
Copy acha?
Copy din and Joseph print out din.
Yes.
But I am handing up the copy. কোথায় ওরা রেখেছে ভগবান, কালকে আমি আগের দিন আমি সত্যি রেখে দিলাম কপিটা,
তুই আমাকে দিস না?
দিলাম না বার করে একসঙ্গে।
না রে বাবা, আমার এখানে ফাইল তো আর কোথাও নেই। না গো বাবা, ফাইল
I request your lordship to take up this order. First paragraph. In the writ petition, the order dated so and so issued by the secretary of the Balika Shikha Shodhan is under challenge. By the said order dated so and so, it was intimated to the petitioner that her service is no longer required by the said school. While considering the writ petition, at the motion stage, Mr. Basu, Saptangshu Basu was appearing. had taken the maintainability of the writ petition on the ground that the school is an unaided institution and the petitioner is not an approved teacher. Therefore, the issue involved in this writ petition does not come within the ambit of public law, and the petitioner needs to approach other forum in pursuit of her remedy. Then, since preliminary point of maintainability of the writ petition is argued before this court on behalf of the said school authority, this court has decided to delve into the issue at this stage after hearing the learned advocate representing the so and so. Then, while considering the point taken on behalf of the said school authority on the anvil of the ratio decided on St. Mary, this court is required to consider the conclusions arrived at by the Honorable Supreme Court in paragraph 69 along with so and so. But the Marwadi Balika Vidyalaya, another order of the re-grading school has been quoted. Then, in order to decide whether the issue involved in this writ petition is amenable to the writ jurisdiction, this court is tasked to consider the observation made by the Honorable Apex Court in St. Mary so and so. While deciding the issue whether the writ petition is maintainable at the instant of an office staff of an educational institution which is unaided minority institution, the Apex Court has held in paragraph 69 of the so and so that if the issue involved in the writ petition is not relatable to the statutory provision or issue has not cropped up in exercise of the public function of such institution, writ petition is not maintainable. Then, but in the present case, the court is considering the termination order dated 21st December 2023 issued by the school authority, which is neither an unaided institution nor a minority institution. School receives grant in form of dearness allowance for disbursing salary of the teaching and non-teaching staff regularly. That aspect has been considered by the Apex Court in paragraph 50 of the St. Mary's. Then, in addition thereto, this court has advantage to rely upon the ratio of Marwadi Balika, wherein it appears that the respondent teacher was also not an approved teacher as accorded by the state functionaries in the education department. It was decided by the Apex Court that the writ petition is maintainable since the school was in receipt of dearness allowance. Similar situation prevails in the present case where the school is in receipt of dearness allowance and the petitioner before this court is a teacher who has been terminated by the dint of the order dated so and so after putting the service of more than 9 years. Then, at the first blush, it transpired that without following the procedure as contemplated under Rule 28.8 of the Management Rules, the service of the petitioner has been terminated. Neither approval has been obtained from the West Bengal Board of Secondary Education as required under the said rules of 69. Present case comes under the exception carved out in paragraph so and so, since the petitioner filed the writ petition being so and so for her approval and during pendency of the first writ petition impugn order so and so was passed. However, at this stage, this court finds it inappropriate to make any further observation with regard to the validity and legality of the termination order, since according to this court, issue needs to be decided on affidavit. Since this court has already expressed its view with regard to the maintainability of the writ petition, this court has no hesitation in interfering with the order of termination which has been issued by the so and so. According to the order of termination dated stayed until further notice.
Yes.
Well, we are on the same. Well, this order was assailed before the Honorable Division Bench. The Honorable Division Bench did not interfere with this order.
All right.
So, and this is in this case, the locus standi of the management
In issuing the order is
in
questioned.
issuing the order is under challenge.
All right.
The management is approved by the board.
All right.
Lordship.
Yes. Are you aware as to whether the administrator is still there?
There is another the proceedings filed by the trust 2010 regarding dispute of nomination of the members of the managing committee. 2010 and 2018 both the writ petitions, my lord, they are pending before the Honorable Justice I. Chattopadhyay. And
The
they are
one at page 60 is pending.
pending.
Managing committee,
And there is an order to hear the matter, trust writ petitions and these writ petitions.
Together.
There is an interim order will continue till the disposal of the writ petition.
continue means who is continuing?
60, page 60,
Page 60,
disposal of the writ petition,
the appointment of administrator has been stayed.
state,
What about the managing committee? Whatever was there,
is still functioning.
there is no managing committee because that is the observation of managing committee.
তাহলে তুমি শেষ করে নাও আমি তারপর
Yes, page 59, the president of the
I tell you lordship, that issue has been raised before the Honorable Justice I. Chattopadhyay, and prior to that matter was heard in part before Justice Aniruddha Rai, and probably there is an order directing the authority to managing committee to continue its function, and no financial whatever one order has been passed, all these orders I can produce. Now whatever this writ petition I just produce. You will also kindly turn to page 51. Just you will also kindly page 51. 51 of the writ petition.
Yes.
What is the grievance of the writ petition? After the order of this Honorable Court, the District Inspector of Schools consider his prayer for approval of his service. Last paragraph. From the submission and material records, it reveals that 25 assistant teacher in normal section and 16 assistant teacher in higher secondary section, in altogether 41. Assistant teachers are working in the school, though the sanctioned strength of teacher staff is 50. By DI number such and such. In course of the time, number of students in the school has decreased enormously. Consequently, the number of approved teachers for exceed the admissible number of teachers arising out of the student teachers ratio. Considering the student teachers ratio, number of teachers in normal section should be 16 and in higher secondary section should be 20. So as per the student teachers ratio 36, 16 plus 20 assistant teachers are required for smooth running of the schools, but the existing number of approved teacher is 41, which is greater than the admissible number of teachers, that is 36. Moreover, physics, chemistry and mathematics teachers are necessary for science stream, and the school authority is likely to recruit the full-time teachers in some same subject shortly as submitted by the school authority. On the careful consideration, careful perusal and consideration is available of office records and submission made by the petitioners as well as the school authority. IDI hold that the service of the petitioner mentioned above cannot be approved as assistant teacher in the state schools. This was happening in 2016. Petitioner did not challenge it. So
This
after
is the approval. I don't want approval.
his service has been regretted by the DI of schools.
It is you who appoint him.
I appoint him on temporary basis at the material point of time.
Yes.
There is a students. Now when the proposal same as per order of this court, DI is found that the teachers are not required in the particular subject. Number of teachers have been appointed wrongly. As per rules, his service cannot be.
You are the creator of all mistake.
That is why after 16, after 4 years, 2020, students year by year deteriorated. Now the students in my opinion opposition 2025 in another matter the only কত students আছে I am not in a position to provide the salary. That is why school needs not in a position to provide all the teachers to pay.
How many students? 100 students.
The present student I have annexed in another matter. Secondary section 376, higher secondary section 239.
So there are quite a number of students. You said only 100.
Number of approved teachers are there.
How many?
That has been recorded in the service book, page 53. You will also see approved page
52. This is in 16. We are in 26. 10 years have elapsed.
26. You will also see I have annexed also all the approved teachers. page 17 of another matter I have annexed.
Another matter is not here.
Yes,
You file
next matter.
next matter.
Next matter I have
Opposition
annexed
আছে?
for these oppositions was valid upon 2022.
2020.
2022 and this is the 25.
This is 25. 19.
Page 17 you will also kindly see.
Page 17. Yes.
Date को था
Actually,
वो date.
next page जाओ, next page. No. Yes, page 16, there are students well the normal section 376 as on 5th January 2026.
What was the petitioner teaching?
Petitioner probably English.
English in the English medium school or the Hindi medium school?
Hindi medium school, I was teaching Hindi.
Hindi in the Hindi medium school.
In Hindi medium and English in Hindi medium.
English in Hindi medium.
Serial number 4 is English teacher, 5 is Hindi teacher. It's 2011
Page 17 of the said opposition, you will also kindly see language group, admissible 5, existing 8 at the top. 3 are excess. That is why DI has rejected his approval.
No, that is different. If the school requires, the school can pay and the teacher can stay.
That he was appointed, you will also kindly see, he was appointed in the year 2005. Now the day to day, the year by year, the students ratio has deteriorated.
The impugned order is of 2018.
2016.
16.
That has not been challenged. It is now accepted that.
No, approval has got nothing to do with this.
No,
Termination approval are different.
Rejected by the DI. Well, the school is not in a position to provide the salary to the unapproved teachers. And we will also
So that is different, but how can the order of termination be passed by a committee which does not have any existence in the eye of law is the challenge. I do not want to know anything. You constitute your committee, then take steps.
page 53, that is the termination letter that has been categorically stated, paragraph 4.
How could you issue this termination letter when the person issuing it doesn't have the authority? This is
That is the managing committee is still valid as per order of this
also,
honorable.
yes, what is the stand, board stand?
Well, board malad, I have twofold thing. Whether termination, legal, illegal malad, I am not on that.
Yes.
Submission is that this is an unaided school, be de-gating or not de-gating malad, an unaided school recognized by West Bengal Board of Secondary Education and their management rules are under the West Bengal Board of Secondary Education. So malad, the maintainability point here I support that the petition is maintainable, that is one point. And the second point, Lordship, as it is an unaided school, after 2018 amendment, Lordship, this disciplinary proceeding of the school is entirely upon the school managing committee of the school. Here board has got no function to intervene into the matter because rule 28.8, which my learned friend cited the other day, your lordship, the total rule 28.8 has been omitted. So now whether this termination is legal, illegal, natural justice violated,
That is different. But then it is the president of the board which is saying that there is no managing committee.
Still till date because there are other matters pending. So
That means the managing committee is not there.
is not there. But there
The managing committee,
if I remember properly, your lordship, is fight between two trustees. One person says I am the trustee, other says I am the trustee. There is a fight.
that means the managing committee which is functioning as per orders of court.
Last 20 years, there is no election.
No election.
Imagine.
20 years, no election.
20 years.
Yes. No election.
17, last managing committee expired 2017.
Then what is to be done?
And we will also will find page
Your lordship may direct for
3 of the repetition. The lordship will be stand taken
Court
by
cannot direct constitution of fresh managing committee because the issue is pending consideration before another bench.
that.
The court, this bench cannot even enter into that.
It is better for hear all the matters.
No, somebody is hearing two matters. Why will This court issue,
Before this judgment.
that is pending.
2010 and 2018, both the writ petitions.
And the school is not taking steps.
করা হয়নি।
The school is not taking steps.
See the interesting part, 2010 and 2018, two writ petitions are pending. Obviously the school is enjoying the interim order. For last 27 years, there will be no.
2010, my lord,
So for last 26 years,
legally entering into the.
I release the matter, you get it assigned over there because the matter is being heard.
but
You finish
this is
it
an
off.
absolutely different context.
On a senior bench, they have the
Context-
matter.
Context is different.
Senior
Context,
bench will the matter.
context is different. But then the managing committee is functioning in accordance with the court's order. This is the problem. Assuming it is defunct, but there the umbrella of the
See.
court is there. Do you get
But,
it?
কি বলেন sir?
On a senior bench, can't you hear it?
No, no, some other bench is hearing.
No, মানে that bench is not regular. Just in Charity, Raijali is sitting there. It's a Jameen. It's not a regular bench. Well, it's a matter which is not.
Last order,
This may not take more than 20 minutes.
Matter can be resolved.
Yes.
last order, my lord, the 8 April 2025, there is an order that both the matters be heard together.
By Justice Sharaf.
Receives, no. Before receives,
Yes.
my lord, the 2010, my lord, the trustee file an affidavit in opposition, my lord, that is pending before Justice Raichot.
And the affidavits are over.
Affidavits have been,
Then
There is a hearing
both this matter before in this court.
matter is,
before that bench.
But Justice Chattopadhyay is not a regular bench.
So you can show this and get it done. Let me see what order you are relying upon.
It is Joseph.
your lordship, my lord, that have 24008.
দেখুন তো
WPA appellate side 24008 of 2010 বা ওই 18 এর নাম্বারটা মারলে চলে আসবে 25 মারবে
হ্যাঁ বলো 25826 WBA
18 টা মারবে 18
of
25826
ওই বললাম তো
25826 of 2018
হ্যাঁ
আমরা তো ফিক্সড করেছি
জজ সাহেব তো বসছেই না তুমি মামলা করবে কি করে কারণ এবার এনজয় ইন্ট্রিম অর্ডার ফর ইয়ার্স
প্যাকেটিং তো করবে না
Are you a party over there? No.
very interesting point Mr. Jana
Teacher.
Didi এক মিনিট মানে Mr. Jana has page 70 in the opposition Mr. Jana has annexed the approved teachers list we are unapproved what about the unapproved teacher list let them show
teacher list beyond মানে the sanction
I am on a different point in unapproved teacher list where I am standing
8/4/2025.
8/4/2025
হ্যাঁ
that's not it
দেখি তুলুন একটু
এটা লাস্ট
The argument has been commenced.
at the head my lord the lawsuit can you see 18 2014 and 2010 three writ petitions clubbed together and my lord the one file my lord the school another file by the trust they are trying to enter into the school
And another file by one of the teachers.
Teachers.
Sham Shalon Upadhyay.
Samson Upadhyay
Samsulon Upadhyay.
Yes.
His service also has been terminated.
এটার একটা পাতা দিন না আমাকে
But he has.
judge সাহেব একটা page
please come upon hearing the submissions made on behalf of all the parties. It appears that
এখানে করে দাও
the petitioner is challenging the action of the
পাঁচের
challenging the order of termination issued by a defunct managing committee of this school. The petitioner is an unapproved teacher of the said school. Stop paragraph. The
দেখ না অর্ডারটা দেখ না
তোরা খুলেছি তো
দেখাচ্ছি
এই তো ও, আমাদের হাজারটা লোক
ঠিক আছে
president of the ad hoc committee of the West Bengal Board of Secondary Education
সেটা কেউ দাঁড়ায়নি
passed order on 15th November 2018 appointing an administrator for reconstitution of the managing committee of the school. Uh, so the managing committee managing committee আগে, the election of the managing committee was last held in the year 2007 and the said committee got extension from time to time up to 31st of October 2017. Stop. Thereafter, election of the managing committee has not been held. Stop. The appointment of administrator was challenged before the court and the said order stayed till the disposal of the writ petition. Stop. The said writ petition along with two other writ petitions were taken up for consideration by Hon'ble Justice Rai Chattopadhyay on 8th April 2025 and argument started on the said date. Stop. The all the three writ petitions, not all, three writ petitions in respect of the same school is pending consideration before the said honorable court. Stop paragraph. Here admittedly the impugned order of termination has been passed by the managing committee. Stop. Whether the said order is valid in the eye of law or not has to be adjudicated. Stop. If the court opines that the managing committee was valid on the day the order of termination was passed, comma, then the point raised by the petitioner cannot be substantiated. Stop paragraph. For convenience and also to avoid conflicting judgments, comma, this bench releases the matter so that the same may be taken up by the bench taking up three other writ petitions in respect of the same school and the same issue. Stop. Let the matter be placed before the Honorable the Chief Justice for necessary assignment. Same order in the other matter.
Item number 4, I am led by Mr. Bush.
One line in item number 4. The original affidavit in opposition filed by the school cannot be traced. Stop. The department is directed to reconstruct the same, relying upon the photocopy of the affidavit in opposition that has been filed by the learned advocate representing the school.
Grateful letters. Grateful. This secretary has a luck. 2 বছর ধরে চলছে বক্তৃতাও চালাচ্ছে
Lordship, I am for the petitioner led by Mr. Sudeep Ghosh Chaudhary. In the order, Your Lordship, advocates for the petitioner has been recorded as Ujjal Rai. It needs to be recorded as Mr. Sudeep Ghosh Chaudhary.
Give your slip নামটা ঠিক করতে হবে। Advocate's name changed. Give a slip, what will be the proper name, it will be inserted.
I have given.
Has come at the instance of the department. I think.
Please,
My lord, we are challenging that expiry panel in respect of group C and D.
There is one problem. The department has brought this to the notice of the court that there is a direction for addition of the names of the applicants as respondents. But the prayer was possibly for adding them as petitioners. Who are the applicants? Who are for the writ petitioners?
Yes, applicants were similarly circumcised.
Alright, so they should be added as petitioners in the cause
Were
trial.
added as respondents, then respondents.
Then the respondents will be supporting the petitioners.
Yes.
It can be that way. But then this is what the department intend. Are the applicants present? Nobody.
Some of the applicants were
Nobody is there for the applicant.
applicant
I therefore can want some of the applicants.
Yes.
1, 2, 3, 2, 3,
And
2, 3, 4, 5, 6. Majority of the camps.
In that case, they can be added as respondents,
Yes.
but then supporting the case of the petitioners. And no change.
I'm there was also a direction for on us to file a report by the 6th.
It has not come for that purpose. It has come only for this.
I was only
Extension of time.
2 weeks.
No, my lord, that matter is, your lordship is in session of that matter, my lordship is hearing.
Which matter?
Yesterday,
Tainted list?
yes, paragraph 31 of the Supreme Court.
Yes,
judgment.
yes, yes.
Here also the point is same.
There you filed your opposition. You
There
you can use the
differences-
same opposition.
Only difference is they are teachers, we are non-teachers.
Alright.
That is the only-
Issue is the same.
Yes, sir. Interpretation of paragraph 31, 32
Check
of
up,
the.
you can manage possibly. And the petitioners will be heard, that matter is being heard. It will take some time, you prepare it in the meantime. Today I am not passing any order.
We may not
Alright.
even use a reply. They can,
I am not passing any order today, they will be added as respondents only.
your lordship,
I have to fix that matter.
yesterday your lordship has kept that blank, my lord. If your lordship,
কবে আসছে বললেন? Friday, 20th.
20.
This Friday.
This was 20th.
This is 23rd.
Doesn't matter, hearing cannot be done in one day, this will take
In
time.
any case, it cannot be done. But
Right? No changes over here.
on
কিছু হবে না,
23rd, my lord,
ডিপার্টমেন্টকে
if
একটু
your
বলে
lordship,
দেবেন যে এখানে রেসপন্স সেরকমই থাকবে।
yes,
It is there already on 23rd.
yes, it is returnable on 23rd. I'll be paid for tagging, basically, your issue will be,
It will be tagged. I am hearing it on staggering basis, so it will be tagged. Next.
deep obliged.
Yes.
The petitioner was assistant teacher, my lord, instead of headmistress.
Assistant teacher হবে, headmistress হচ্ছে হবে। Alright.
Or I beg to appear for the petitioner, my lord. That came up at my instance, my lord. My lord, the petitioner before your lordship are the my lord, the untended teachers who were given the opportunity by the Honorable Supreme Court in the Boishaki Bhattacharya matter, my lord, to revert back to the older post, my lord.
So many petitioners together, why?
My lord, all these petitioners have come before your lordship. My lord, the state respondents, my lord, have, despite there being an order of extension by the Honorable Court to complete the SLST proceeding, second SLST proceeding till 31st of August 2026, have not extended my lord, the time period to revert back to the older post, my lord. They have given a notification on 29 December stating that it has been extended. On the very next day, on 30th December, my lord, the same notice has been withheld, my lord. My lord, on a similar circumstances, item number 5 was also filed, my lord. Next matter, my lord. My lord has directed in that matter to the state respondent to come up with an instruction, my lord. On a similar point, my lord,
I'll take a 5 first in that case.
Let's take both the matter together, my lord.
One thing, my lord, in five,
Why you?
my lord, in 5, my lord, I'm appealing for the state.
State.
Yes, my lord. My lord, in this matter, my lord, the learned AT has been engaged, my lord, but the instructions, my lord, cannot be, my lord, kept on any other day, my lord. Both the matters, my lord, may be kept. In 5, my lord, the AG is leading me.
Let me see the order once. কি আছে একটু বলছি 5 নম্বরটা?
ফাইলটা দিন। দাদার কাছ থেকে বলবি। সামনে কি হবে না?
Tell me one thing, did the Supreme Court extend the time for joining?
No.
The Supreme Court extended time for completion of the selection process.
Yes.
My lord, it is.
Take your lordship to this. Lordship has seen, my lord, the annexes in item number, page number 53. So this is one of the order where
53, 53,
54 you must find one of the relevant.
54.
So,
Extension of time for completion of the selection process. In such and such, or in the event the process is complete, till this completion of the would mean culmination of issuance of. Where is the order
My lord, can I
Paragraph, my lord.
already appointed who are permitted to continue shall continue to hold their post till such time of completion of the process?
so now, my lord, the
process
process
is
is continuing. Because
Yes,
what happens here, in this meantime, my lord, there has been some previous extension in paragraph now 47, my lord, there has been a specific direction from the Honorable Court that those persons who want to join back in this meantime, they can just go and join back. Now, my lord, what happens in this meantime, after this order was passed, so, my lord, the time for, my lord, the process for selection, my lord, has been extended. Our service for which we were there in the, my lord, employment had been extended up to 31st of August. In this meantime, the order, this Honorable Supreme Court itself said that those persons in paragraph 48 and 49. There, my lord, the Honorable Supreme Court said that these persons, since disabled persons and other untainted teachers, they will be able to participate, and till then they will be able to continue. And this is just after paragraph number 47. So, my lord, this is why we could just take it like the extension of time for the purpose of being there in the posts, as well as, my lord, the time which has been given in paragraph 47 should be extended.
how come?
So this,
The court is very clear that the untainted teachers who are already appointed, they will continue,
yes.
right, till such completion of the selection process. This is a different thing.
Yes.
Appointment of the fresh candidates, untainted candidates is one part.
Right.
Reverting to your Earlier post is a different part. Where is that order?
So that's kindly see paragraph 47 of the main judgment.
I am carrying
For
that.
paragraph 47 of the main judgment, that is at page here. Kindly see paragraph 47 of that main judgment. Yes.
Is there any scope?
No,
The appointed-
I will just explain to you also. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state, government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. This application must be processed by the respective government departments to bodies within 3 months, and the candidates will be allowed to resume their positions. Therefore, 3 months times were given. Number within 3 months we could not able to do it. Then a content application was filed before the Supreme Court by these categories of the teachers. Then we have to give an undertaking that by 15 November we will complete everything. Now by 15 November we have done from the SSC level all we have done. Now the government order first which was issued, that is the extension was given, but it was revoked by reason of the interpretation of 47 and the content application order ta ache the barcode, but just I showed you content application order ta barcode 19th September 19th September no, read the 19th September order.
Yes.
With the Supreme Court's order, can you excuse me? It can I take this one? Yes.
No, it's all right. You read.
No. By way of three contempt petitions, the petitioners allege violation of the directions of this court in paragraph 47 of the judgment dated 3rd April 2025 in civil appeal so and so. It is a specific case that despite their pleas to the repatriated to their earlier jobs in the education department of the state, in terms of the directions of this government, steps are not been taken. Issue notice written over on 27th October 2025. Then 27th October. A learned counsel appearing for the state of West Bengal states that the candidates concerned will be sent back to their former post in terms of the directions of this court in paragraph 47 and so and so. Judgment by 10th November 2025. Released on 17 November 2025. Then 17 November 2025 the order is learned counsel for the petitioner states that the petitioners have now been permitted to join duly pursuant to the directions of this court in paragraph 47 of the judgment in the state of West Bengal versus Boishaki Bhattacharya and others. We are further informed by the learned senior counsel appearing for the state of West Bengal that the seniority and other entitlement of these persons would be preserved, including their eligibility of grant of increment as directed by this court. In the event the petitioners have any other grievance or issue, they would necessarily have to seek redressal thereof by way of an independent proceedings in accordance with law, as the same cannot form in the subject matter of this contempt case. This is the order. Now, what has happened, that your lordship knows that it was extended up to 31st, but 31st August is the outer limit. In the meantime, whenever if the counseling started and it is given to the board and board gives the appointment, even in the month of March or April, someone will go join and then in place of who was working, he has to go. That untainted candidates. So 31st August is the outer limit. Prior to that, all we have to do this works. Yes. And accordingly, it has been done. Now we have to work within that first of all under paragraph 47. 47 3 months were given. There was certain fault on our part. Then they filed the content application. Then the entire thing was processed. Then 10th December, within 10th December, we have given the orders to everyone. 10th November. Then 17th November, it has been disposed of. Therefore, my humble submission would be before your Justice Miller. In this petition, now there is no scope to interfere.
Where were the candidates working?
In different, my lord,
in item number 5, my lord.
just submit with respect to item number 5, then my lord is saying about 4. So, my lord, in item number 5, all those persons, my lord, have been working on the DPSC Malda. District
DPSC Malda.
So, my lord, what happens to what my learned senior my lord says in this matter, my lord, if I just could take your lordship to the order which is passed by the Supreme Court for extension of the time, if I just could take your lordship to that one. The first one. So, my lord has seen this is the order of 17th April 2025.
What is the date of this order? You
My lord,
have it
17th
over?
April, the page in page
17th
bottom.
of April.
So there your lordship will see that there has been a
Advertisement.
yes, there has been a prayer, my lord, for extension of time to conduct the examination and everything. And by that time, so that these
Everything could
individuals
happen.
work in 9,
Everything
10,
could
11 and 12.
One of the exams.
Kindly sees the second page, the relevant part, if I could take your lordship to, we clarify and thereafter we are not inclined. May I please, my lord? We are not inclined to accept the prayer in the present application insofar as non-teaching post in Group C and Group D are concerned, as the member appointee specifically found to be attend this said process is substantially high.
We are inclined, not inclined.
Yes. So thereafter, secondly, teachers not found to be tainted is that students undergoing study presently should not suffer on account of the lack of teachers and the lapses and failures which have resulted in the order passed by this court. So, my lord, this is the reason for which, my lord, the extension was allowed. Now, by this time, my lord, what happens? After this, my lord, subsequent extension as well, lordship has seen up to 31st of August. So, by this time, my lord, what is happening, my lord? We have been all working here. Not only that, we have been, my lord, serving to this HS examinations. We are giving papers with the 9-10 examinations. We are invigilators. So in this meantime, my lord, since this was the basis for which, my lord, the extension was granted by the Honorable Supreme Court, and subsequently we said,
No, what are you apprehending?
my lord, I say that since it was only my lord, paragraph number 47, it was said that the initial extension by the Honorable Supreme Court was 31st of December. So, my lord, since after that, nothing specifically has been stated in the Honorable Supreme Court's order. Rather, it has been left to the Honorable High Courts for deciding. If I take your lordship,
What exactly is your apprehension?
my apprehension is that, my lord, since the 31st December is gone,
Working.
I am working here. Yes.
Yes, so your service will continue till the appointment letter.
No doubt about that. No doubt about that. No doubt about that. So, my lord, I apprehend that if I am not right now permitted to get back to my previous employment since 31st December, so I made, my lord, letters to them. So now, my lord, what happens after I made
You
the
applied for reversion.
yes.
When?
my lord, prior to 31st of December, absolutely.
3 months was the time.
So I did that. So accordingly, my lord, the extension was accordingly, my lord, the opportunity was granted to me.
No, not
my
to
lord.
you.
Yes.
Not
Now
to you.
that if I just can take your lordship to what, my lord, the Commissioner of School Education says
Ah.
in 28 December, Commissioner says if I just take your lordship to the last but one page of my annexes. Because I have, my lord, annexed of my documents in which, my lord, I have made this prayer for extension.
Page 75 is 29th of December.
Yes, my lord, that one, yes. So page number 75 would be, my lord, the order. So after my prayers of, my lord, extension of time to get back. So my lordship kindly sees what is the wording of this letter. So it is 29th of December 2025. So here, my lord, the paragraph number 1 is Honorable Supreme Court, and then the next paragraph is paragraph number 47 quoted. I'll skip it up. My lord, then, my lord, kindly see the next page. Accordingly, the eligible candidates who had applied for allowing them to join to the previous service in the schools, primary or secondary, were allowed by you to join in their previous service. In the meantime, on 18th of December 2025, the Honorable Supreme Court has extended the period of completion of the selection process till August 2026 in such and such. After the Honorable Apex Court has passed such order on such and such, a good number of candidates may have prayed to you for extension of joining period in the old school, which is pre-2016 recruitment, by 2016 recruited candidates as per the order of the Honorable Supreme Court. Considering the situation, I am directed to advise you to allow extension of joining period if applied by the individual candidates. This is issued with the approval of the competent authority of the Department of School Education, Government of West Bengal. So this was, my lord, pursuant to my prayers that let this be extended pursuant to this 18th of December. So, my lord, by using their own discretion, my lord, they have done that. My lord, then my lord sees on the next page. Immediately on the next day, they say that we are keeping that particular 28th December in abeyance. 29th. So this is why, my lord, I am being aggrieved here. So my lord, I tell your lordship that since it is, there are two things, lordship can appreciate. Not only the fact that I have been engaged as invigilators, as teachers, we have been giving this, taking up the answer script of the board examinations. But also, lordship can appreciate here right now, if I just am right now, in this meantime, if I would have been back in my previous employment, most of us, my lord, have applied for the 2025 selection process as well, and right now, my lord, some of them are even, my lord, in the process of getting employment. So, my lord, now in this meantime, my lord, if I went back in previously when this time was there in 31st of December, there would have been, my lord, another anomalous situation. So this is why I just pray before you. We accordingly prayed before the commissioner that kindly extend the time for doing this, which they have done by exercising their jurisdiction. So that is a reasoned order. So then, my lord, the next page is not at all reasoned by keeping that particular order, my lord, in abeyance. So I challenge that particular, my lord, decision of, my lord, keeping the previous order to be in any abeyance, which is completely unreasoned. Kindly sees what is the reason given in the order impugned. Page number 77. I'm sorry, my lord, it is not legible, my lord, if I just could place. In reference to the above, this is to inform you that as the issue of extension of time for rejoining in the previous services has been placed by some candidate for the Hon'ble High Court, Calcutta, I am directed to request you not to give any effect to the office memorandum dated 29 December until further order. So, my lord, this is completely something which is, my lord, not reasonable at all. What High Court, Calcutta? What order? But it is not even mentioned. But, my lord, our chance to, my lord, get back to the previous employment is in abeyance by force of this order.
My lord,
Sorry, my lord, in item number 4, my lord,
my lord, can I make the submission?
Let him finish, I'll hear you. Let him finish, he is in 5, you are in 4.
Yes.
Yes.
this is my submission to your lordship that because of this court, this Commission of School Education has already, my lord, exercised the jurisdiction and accordingly, my lord, passed this reasoned order, which is completely reasonable.
Please come to 47 once again.
Yes, ma'am. I'm sorry.
Some of the appointed candidates
Exactly.
who do not fall,
Appointed candidates who do not fall within the category of tented candidates may have previously worked in different departments of the state government or with autonomous bodies, etc.
wait, who are these candidates? Who are these set of candidates?
Who are not specifically said to be tented.
That is separate. Not tainted is one thing, and they have worked in different departments of the state, not in the 2016 recruitment process. Prior to coming into the 2016 recruitment process, there may be others who have worked somewhere else.
Yes.
It may be these type of candidates who have been,
State government.
They are that persons. They are coming within that block.
you were in appointment prior to 2016.
Yes.
In
You
fact,
so,
yes.
maybe primary, but then not the 2016 recruitment process. Apart from that, you are there.
Yes.
You are those set of candidates who had worked.
Right.
All right. Now you want to revert, and you can always revert in terms of paragraph 27. Where is the problem? 3 months time was given for processing. When did you file the application?
My lord, I filed the application in this 3 months. I have annexed these applications all together.
3 months from the date of the judgment of the
Yes, I did.
Yes.
And
Right.
subsequently that was allowed.
allowed.
Allowed means, my lord, they said that it is to be extended by this time, but now. So they have issued separate orders for submission. Now, my lord, after this, the Commission of School Education.
Where is the question of extension of your service if you are reverted back to that original position, not in the 2016 recruitment process?
It's not extension of the service I'm praying. I'm just, my lord, trying to make myself clear, my lord. I am just saying that I am there in the service of the, that
3 weeks span.
cancelled selection. Right now I'm there. So I am right
Cancelled selection goes.
now goes. But still I'm continuing by means of the extension of the Honorable Supreme Court.
No, you are continuing in terms of 47 to the earlier position. not the 2016 recruitment position.
I am putting by date of this 2016 recruitment, I want to go back to my previous pre-2016 employer. So I am right now I am right now working in the HS schools in which one are the so I have my employment here is going to end in 31st of August. No doubt.
Obviously.
No doubt of that. I do not even dispute this.
Ah.
So my lord, now in this particular order, there has been a window that has been made for those persons who are not tenanted and was working some other places.
Right.
So I
Pre-2016.
my lord, pre-2016.
So what you want? You want to go back to pre-2016?
Yes.
Who is stopping you?
So because the time is already gone by 31st of December, I ought to have done this. My lord, the Supreme Court said I ought to have rejoined. So now, my lord, in this meantime, I prayed so that my extension of time to go back to the previous employment be made. I wanted the extension of
Did
time.
you make the application in proper time?
Absolutely, my
Now it is the respondent's responsibility. Where is the question of extension of your service?
No.
This I do not follow. I'm sorry, I cannot follow.
I'm sorry, my lord.
First of all, I'm sorry, Mr.
I'm sorry. Let my Ganesh Singh, my lord.
All right.
Paragraph 47, if your lordship is convinced with the interpretation made by my learned friend below, that this is a general extension not applicable to those persons who had discharged their services prior to 2016.
Right.
Clear? If that is clear, Milord, then the further extension subsequently made at the instance of the respondent, Milord, up to Milord completion of 31st December 2025 and Milord thereafter 2026 August. This was there. Now, Milord,
No, there is a problem here.
question here is, if it is not there, then Supreme Court, Milord, there must be a specific judicial order which runs to the extent that yes, this has been modified and Milord, there is an extension. Supreme Court on the contrary, page 133, 134 of your lordship's brief categorically state in item number 4, we are not inclined to accept the prayer in the present application insofar as a non-teaching post such and such CD are
This service is meant for the 2016 recruitees, not for you who claim
I am also 2016. I am also 2016 recruitees. My appointment stood cancelled. That is why Supreme Court page 47, paragraph 47 said some of the appointees, Milord, who discharge their duties, Milord, discharge their duties mean prior to 2016 in the various departments of the state government.
Right.
I squarely come within, Milord, as my learned senior friend fairly, Milord, submitted that it applies to me also because we are falling under the category. The question is, what is the concept of extension? If it is
First, I need to be satisfied under which category you fall, pre-2016 or the
First of all,
2016.
Milord, before 2016, we had been discharging our services to various
Elsewhere.
government. 2016 elsewhere. Now in 2016, these are the successful candidates.
All right,
who were appointed.
2016 is different. 2016 is different. There are two set of candidates. One is pre-2016, one is the 2016 whose appointment stood nullified.
To correction, no, because 2016 appointment which was challenged, ultimately Milord nullified by the Supreme Court by its order dated 3rd April 2025. It indicates that the selection process initiated in the 2016 Milord, that is Milord, cancelled. Now, Milord, we were the selectees, we were discharging our service under the commission of the government. We were school teachers. Now, Milord, before 2016, we were discharging our service under the various state departments. Paragraph 47, Milord, talks about us. Clear, my lord? Then, Milord, when we lost our job, ultimately by reason of the order granted by the Supreme Court, our services were extended, Milord, till 31st December 2025.
Your services means the 2016 recruitees.
Yes.
Their services were extended.
Correct. Now,
Either you can go back to your own job
I made an application.
prior to 2016,
I made an application.
or you can
I
continue
made an
with
application, my lord, I'm extremely grateful. I made an application to the authority in terms of the Supreme Court within time.
Yes.
Now, Milord, Supreme Court, while deciding dealing with the issues, in Milord, page 133, in category 30 or 17 April, it says categorically, Milord, that what has prompted us this order in respect of assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of lack of teachers and the lapses of failures which have resulted in the order passed by this court. That is why, Milord, this tenor of the order, Milord, has not been modified and or cancelled by its subsequent order. It extended today, Milord, if the 29 December order categorically states that this extension made applicable to
us. Now we are 30th December, which he has shown to your lordships, which is impugned herein, which categorically will not discloses no reasons. Because it never says that in supersession of the earlier notification for this reason, the bar and the affidavit cannot supply any reason in support of 30th December 2025 order, because
I still cannot follow, sir. You,
if your lordship is convinced that we have been discharging our duties in the various state departments 2016, if your lordship is convinced that 2016 recruitment we became successful, we have been discharging our duties as a selected candidates in 2016. 2016 recruitment process, ultimately, Millard, it was declared as nullified for various reasons. Our services, Millard, we are categorized as untendered candidates.
tell me one thing. You want to go back to the pre-16 one, or you want to continue with this?
Pre-16 one, such order, that is pre-16 one, your lordship is absolutely right, but 30th December 2025 order, this order, impugned order, it discloses no reason. Before, one day before that, it says that this was extended to us. Now, where do I stand now? Where do I stand now today? If the order, if the government says that I am precluded from joining the department, and my service has been extended here, I cannot join in the parent department before October 2026. Extension has been granted till August 2026. Kindly ask the state to file an affidavit saying that what is the present position, because he has to take a responsibility. Why did he issue?
Oh, 1 minute.
Otherwise, you have
Please wait. Please wait. Please wait. No question of staying because the court is confused. You are confusing the court. Just wait. Tell me, state. Two set of candidates. One is pre-2016. One is the 2016 batch. 2016, certain candidates' appointments stood nullified. Right? Out of those nullified candidates, there were certain candidates who were previously in some jobs.
Absolutely.
Right. It is in respect of those candidates that the Supreme Court opened that window to revert.
I'm grateful.
That is different.
Yes, ma'am.
3 months time was given for processing. The applicants may have made application and you will process.
Yes.
Suppose in those matters, not suppose in those matters, where is the question of extension?
No. My lord, I'm grateful. My lord. Only, my lord, kindly has a look
Confused with
at
actually.
Calcutta 47.
Millard, just 1 second, can you allow me to speak, Millard? Then
Either state or commission,
Millard, I'm
clear the doubt.
just wait, I'm doubting. See the position, 6th April, all services have been terminated.
Right.
Only paragraph 47 was an exception. And they are coming within the paragraph 47. Therefore, they were continuing 6th April. Now 17th April, that was an application was filed to allow the persons whose services have been terminated to continue.
To continue, no, you have to make me clear first. You may be clear because you are handling it. I am not clear.
I am just
I need to be clear. The one submission that you said that they will continue, who are these they?
who are these means, Millard, apart from paragraph 47, those whose services were terminated, those who are untented, selectee.
Yes.
Correct. Their services should continue up to 31st, not for this category of paragraph 47.
The selectees untainted provided they are within the 2016 batch.
Correct. Absolutely.
Those who are pre-2016 and the revert back, they may not be teachers. They may be working in some other
Even
departments.
group C, group D, whatever it may be, maybe
Some other departments, not
department.
within
Your lordship is absolutely correct. Not only the institution, but even the department, central government,
Yes.
school, etc., everywhere.
There no question of extension because
No
they
question of extension.
Till
No
the
question of
age of
extension. Just
recruitment.
come to next. Since we couldn't do it, content application was filed.
what you could not do,
We couldn't do within the 3 months.
what you could not do,
Their applications were processed.
you could not process the application.
application.
All right.
They filed an application for content.
Yes.
That the Supreme Court order was to do it within 3 months, but they have not done it. The blame was shifted to us.
All was pre-2016 recruitees.
Yes.
26.
Correct.
Pre-2016.
This batch, this paragraph 47 batch, most of them have filed the applications for content. That time contempt application, no.
Ready, then we got time up to 10th November.
Hmm.
This
To
was happened-
process their application.
Yes, yes.
Yes,
And this order was passed in 19th September,
all right.
10th November. By 19th September to 10th November, we have completed that job.
Hmm.
Can he come to his order of transfer? Can he come to the
Which matter?
item 5?
2514?
Come to the 55.
Yes.
Can you see the order dated 15th October 2025?
Sriporna Chaudhuri. Dated 15th October 25, yes?
Order was passed
Yes.
on the UPSC.
Hmm.
বিয়ের ওখানে কল করছে যদি পার্টিসিপেট করে করবে সেটা বিয়ের তো বিয়ে এখানে এখন আমরা আবার ফেরত যেতে পারি আমাদেরকে জজ করেছিল যতদিন 17 এপ্রিল ওই অর্ডারটা ইলেকশন প্রসিডিং যতদিন কমপ্লিট না হবে ততদিন আমরা চালিয়ে যেতে পারি তো আমরা চালিয়ে যাচ্ছি as per that order
Within 30 days from the date of receipt. That means her application has been processed. Then what remains?
What is, everything has been done. Now
Ah.
what is saying?
Ah.
This case,
His case is 17th April, the order was passed.
Hmm.
For the rest of the person,
Hmm.
that was given 30 up to 31st December.
Hmm.
After 31st December, it was extended up to 31st August. Subject to condition, that all selection process should be completed, everything should be
No,
completed.
sorry, please repeat it, this portion, I couldn't follow.
On 17th April,
Ah.
the Supreme Court passed the order that up to 31st December,
you should complete the selection process.
That is for the fresh candidates that you will appoint.
Fresh,
and
untainted,
Fresh selection process.
selection process.
Right.
correct, fresh
Selection
selection
Ah.
process.
up to 31st December.
Yes.
You must do it. Condition, the untainted teachers, apart from
Paragraph 47, whose services were terminated, they have continued up to
31st
Yes.
December.
Yes.
Thereafter, my lord, we have filed an application.
Hmm.
In that application, court has directed that all right, we are extending up to 31st August.
That is the fresh selection
Correct.
process.
that, correct, your lordship,
But then that has nothing to do with this appointment letter.
nothing to do. So my lord is absolutely correct, my lord, right, my lord. There is nothing to do.
Then where is the question of extension come?
That
Yeah,
we are
if he-
saying that. Mr. There is no scope. My lord, if I allow to continue even, then I am committing again contempt of the order of the Supreme Court.
Whether you are allowing to continue or not, that is only in respect of the candidates in the fresh selection process, and that has got nothing to do with the order of repatriation.
I am saying, if I allow the persons whose names have been blocked in paragraph 47 to continue up to 31st August, then I am again committing contempt of the order of 6th April 2025. That's why I want to say that.
Lord,
That is a complete, even if the state issue, let me tell you also very candid. The order which is being relied upon by them, that was by this statement, that was contrary to the Supreme Court's order. Therefore, they have kept in abeyance.
But one thing, you are sure that the repatriated candidates fall in a separate set
Seven,
and the fresh selection process is different.
complete.
They are two different things.
Completely.
that is his understanding.
Statement has, submission has been made that amongst these persons, some candidate made the application.
That is different.
Different, but just 1 minute. Firstly, details are not there. Secondly, now panel has been published. He couldn't say that yes, my name is in this panel. Those names, whose names are there in the panel, and those who are untainted, But even from tomorrow, the counseling is going to start. 500 persons have been called tomorrow. The moment counseling will be over tomorrow, we'll give the documents to the board. Board will make their appointment. Verifications will be done. State government may give the appointment within 1 month. That doesn't mean the persons who are there untented, purely untented, not even paragraph 47, he will continue. He has to leave. He has to leave. There was 31st December, 31st August is the outer limit for the general 2025 selected candidates are concerned. And this block, this paragraph 47 is out of everything. Kindly appreciate just 6th April, from 7th April, nobody's service was there. Excepting these categories. Paragraph 47. Excepting this category because their applications have to be directed to be processed within the 3 months. The 6th to 17th, only 300 persons were working within, including my learning friend's time. He enjoyed the benefit of, kindly appreciate this, he enjoyed the benefit from 7th to 17th of that order.
Milord, may I, Milord, because it created a cloud of confusion, Milord. 47, Milord, if your lordship says, Milord, if your lordship, Milord, makes it a two different and distinct class, Milord, to that, Milord, I have, Milord, a submission to make. Milord, your lordship is convinced to the point, to the extent, Milord, that before 2016, Milord, we are engaged, Milord, in different department of the state government. After 2016, Milord, selection process is over. We got the appointment letters. We have been discharging our duties. 2016, Milord, came to an end on 3rd April 2025. The paragraph 47 does not, Milord, distinguish. It gives a window to us to make an application for a situation. Supreme Court took note of the fact that since we had discharged our duties prior to 2016 selection, this avenue was created for us. The order, Milord, of the Supreme Court, with deepest respect and with humility, I submit, Milord, it does not make a room for, Milord, making a perception or to make an inroad to come to a conclusion that this order stands applicable after the extension was made till 31st December 2025. It only applies to those candidates, Milord, of the 2025 selection process and not for us. If that is the interpretation of the judgment, because further extension when was made, the Supreme Court did not clarify, none of the parties, not the government, that because the government was quite conscious about the applications or the order of the Supreme Court. Paragraph 47, it creates an additional avenue for us. It does not make a distinct class that this order of extension which was granted
What you'll want version, you'll want to
today, Milord, if your lordship takes this interpretation, then, Milord, I will be jobless on and from this day. Jobless means I cannot, because government will, because my repatriation will be Milord, taken care of after, Milord, August 2026.
Why?
I do not know. There is the assurance. Because
there is an order of repatriation in his matter. Or
where is that in our matter?
There is an order where you have been repatriated.
Repatriation, Milord, is a matter that is yet to be processed. My learned esteemed senior friend has said they may have made application. It is under process, and he said
the applications have been processed.
But what is the outcome? I do not know. I said, Milord, this order 29/12/2025. 2025, the order, and 30th December 2025. Why the government has withdrawn 2029/5? Is it a case of the government? Is it reflected from the order that we have committed a mistake, or it is an executive inroad?
Don't go to that order. You tell me what you want.
I want that this
1 minute.
You are extension of repatriation. Extension of repatriation.
You want to take a chance in the fresh recruitment process also.
I have already taken a chance.
You have taken a chance.
I do. Yes.
You want your previous service to continue?
No. I said, Milord, there is not the correct interpretation. I said, Milord, with humility, that the repatriation.
Have you been repatriated?
No.
Where is your application for repatriation?
No, he has been repatriated.
Please show. Where is your application? That is the next matter. Wait. Let us come to item 4. Where is your application for repatriation?
153.
There are how many candidates over here? Writ petition has been filed by 46 candidates.
Yes.
Can you show me All 46 candidates making application for repatriation.
No, it starts from 153. Rupa Banerjee, the petitioner, her application at 22nd December prior for extension of rejoining date. I respectfully submit this application.
The order was passed in April and you filed application in December?
That is by extension, prior for extension of joining period. I said,
The extension of joining, you can go on filing applications at any point of time.
that is prior to the issuance of 29 December 2025. 137, before that, 137.
Yes, please show.
137. Excellent.
For
29th October 2025, Rupa Banerjee, Chairman, School Council, I have given in compliance with the order of the Honorable Supreme Court of India, such and such, the undersigned request him not to rejoin the assistant teacher of the Binodini Girls High School.
This is on 29th
October 2020.
Then again 22.
October. Did you join?
No, I could not.
I could not.
Why?
17th April order, kindly cease.
Order of the Honorable
Supreme Court said that it is subsequent and it shall be prompted to pass this order in respect of assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of lack of teachers and lapses and failures which have resulted in the order passed by this court. That is, Milord, page 134.
And thereafter,
Supreme Court said.
then after 151,
Then
Page
151.
130, please, sir, page 137, there is an order of the Primary School Council where you have been directed
to rejoin.
to join as assistant teacher of a
I
primary
did
school.
not join.
Why did-
Answer is because Milord, I said my understanding of the order of the Supreme Court, page 134,
Dated-
and this is dated, Milord,
17th April
page 17th April.
2020.
What does it mean?
It kindly sees the order that it says that this order prompted us to pass this order of the assistant teacher not found to be
Which
tainted.
order are you reading?
17th April 2025, page 134 of your Lordship's brief.
134,
That is my understanding of the order.
1 minute,
Then 151.
1 minute, 17th.
এই 4 নম্বরটা দিন তো।
17th April, yes. Yes.
Yes, 17th April. Let me read the order, Milord. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher for classes 9 and 10, classes 11 and 12, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid shall be published before such and such. The examination in the entire recruitment process shall be completed by 31st December 2025. The state government, the applicant, West Bengal Board of Secondary Education, and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 2025, enclosing therewith a copy of the advertisement for the fresh recruitment as well as a schedule therefore, so as to ensure completion of the recruitment process by 31st December 2025. In case the advertisement is not published by 31st May 2025 and the affidavits are not filed by that date, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. We clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teacher insofar as the fresh recruitment process is concerned. We are not inclined to accept the prayer of the present application insofar as non-teaching post in group C and D are concerned.
You are not teaching, so do not read that.
Yes. Then Milord, it says Milord, no, ওটা উল্টা লিখে নাও 134 পড়তে দে পুরোটা in this higher and secondary which has prompted us to pass this order in respect of assistant teachers not found to be tainted, we are coming under this category, is that students undergoing study presently should not suffer on account of lack of teachers and lapses and failures which have resulted in the order passed by this court. Then Milord, 151 page. It is a bona fide understanding of the order of the Honorable Apex Court. These miscellaneous applications are ordered granting extension of time for completion of the selection process concerning assistant teacher for classes 9 and 10 on the one hand and for classes 11 and 12 on the other till 31st August 2026, or in the event the process is completed prior to that, till that date, whichever is earlier, completion of the selection process would mean culmination in the issuance of appointment letters. We make it clear that the untainted teachers already appointed who were permitted to continue up to 31st December, we are coming under this category, shall continue to hold their posts. It is shall, not may, till such date of completion of the process. That is why, under a bona fide understanding of this 29 December 25, government has made an elaborate discussion and passed this order. 31st December, Milord, suddenly change on one line cryptic order, matters ends. So, my lord, today if your lordship says, why did you not join? My lord, I am saying, my lord, with humility, that Supreme Court page 47, 133 and 34, read with 151, it is, my lord, a formal extension. Supreme Court has, my lord, expressed its anxiety that dearth of teacher, my lord, would cause prejudice to the interest of the student. If that is the understanding, my lord, that is bona fide. Commission is not prejudiced by my such bona fide understanding. The government is also, my lord, quite aware of the fact and the ground reality had issued this order. Kindly 29th December, elaborate discussion and, my lord, very recent discussion, my lord, the honorable, the page 162, the honorable Supreme Court in India.
One thing.
Sorry.
Are you agreeable to revert to this page 137 that you have shown?
You are agreeable? I লিখিত নিয়ে নেব আজকের দিনকাল ভালো না লিখিত নিয়ে নেব ইনস্ট্রাকশন I would file a instruction that if you are agreeable then Millard I should be allowed to repatriate. That is the mind of your lordship. Because Millard commission
In October 25 with immediate effect you are supposed to join your previous posting.
I cannot travel beyond the records. I said this is my understanding. The Supreme Court's order 133, 134 clearly may not express its agony and anxiety, students' interest. I did not join because I relied on this.
Student will take care about it.
He is very generous, Millard, and he is a source of fountain of compassion. If he says and if he allows, Millard, that I may join, I do not wish to.
Who is he to join? Because it's a council.
Because he is saying something, Millard.
It is the
He is saying that I will take care of.
letter.
He said that we will take care of the situation.
Go to him and get
No,
the order done.
He said so.
What he says is not the matter to be looked into for deciding a matter.
I said, Millard,
Page
primary school
137.
council asked me to join, I did not join. Your lordship's query is simple.
Yes.
Yes, I cannot
Right.
play tricks with your lordship. I
Exactly.
said, Millard, I did not join. Why I did not join? I sought to explain by interpreting the order 133, 134, read with 151. I did not join. If your lordship says, are you willing to join? No. Give me one day time, I will file a letter, I will join.
Show me the this appointment letters of repatriation of the others also.
All
All are there.
all are there.
What is the
After people nothing. 133,
37 you've showed.
yes.
138 is minor petitioner number 2, Rafia Khatun. 139 is minor petition number 3, Sabgupta Naj. 140 is my lord Rokshinath Parveen, that is petition number 4. Then 145 is Mohammad Asif, that is petition number 5, my lord. I have annexed in that format only, my lord. Then Mohammad Nizamuddin Khan is petition number 6, that is 142.
All 29th of October 2025.
Yes, my lord.
You all deliberately did not join.
Millard, I said.
Took a calculated chance to sit in the examination. Now when you are unsuccessful, now you want to repatriate and you want to continue with your service.
Primary council, kindly sees the letter 162. Primary school said, primary council said, director of school primary branch, they extended, Millard, 162. They did not take any steps.
They only extend,
They also extended,
allow extension of joining a period.
joining a period.
160.
They also page 163. It was a government notification.
29, this is there, this is under challenge. That
No,
is different.
29, no, 38 is under challenge. 29th is not under challenge. 29 grants extension.
We want 20.
So, Millard, between October 2025 to 2025, December, the primary school council was aware of this fact. Millard, that is the,
You cannot come out of the explanation. Your repatriation order is of October. The commissioner's order is of December. What were you doing for
no,
these 2
Millard,
months?
these 2 months.
Your
No,
explanation.
this is my explanation because I said the Supreme Court said so.
Yes.
If your lordship permits us, Millard, if your lordship says that I can join tomorrow, Millard, I can join. Permit me to join tomorrow, Millard. Permit me to join tomorrow. Supreme Court has taken care of. Millard, your lordship has seen, Millard, in many matters that we are not at fault. We are not at fault. It is the fault within our stars, Millard, that we are undergoing through this system. I want to go back. Give me 2 months, Millard. All failures in life cannot be treated as sin.
I'm invigilator in now. I'm invigilator.
It is a failure. I Millard, bow down to your lordship that I did not join. I am an invigilator. I am discharging a duties, Millard. Supreme Court 133, 134 categorically states that students' interest. If I interpreted, Millard, that I did not join, Millard, I was not sitting idle. I joined duty. I did regularly discharging my duties, Millard, as a teacher. I am invigilator. Madhyamik and higher secondary, I am renewing my service, my lord. We are all teachers, my lord.
Now the council is not a party in the writ petition. The one
Primary
that
branch is the party.
is the party.
Primary party. Kindly direct the primary board, my lord.
Number 2. Director of School Education.
Director of Primary School Education, press point number 2.
No, that is the director of school education.
Yes.
All right, let me hear from the state. Item number 4, who's for the state? Yes.
Advocate General, 4 and 5 are both appointed.
There is no argument that the court requires. There is already an order of repatriation. Can the date be extended so that they can go back? This is the only query
Yes.
of the court, nothing more. If because they have been engaged as invigilators and supervisors and the examination Madhyamik and higher secondary is there, they want to repatriate. What is to be done? What is to be done?
Manoj, can I? Lord, after the disposal of the content application, the order which I have read to your lordship, there is no scope by anyone to extend time.
Which time?
This, after 15th October, that
No, 29th of October is the letter of repatriation.
the order contrary to the Supreme Court's order, that is the reason which I have kept in abeyance on the next.
No, sir, 29th of October is not in abeyance.
15th October is the order for
Repatriation.
repatriation.
Yes.
19th October, the content matter was taken up by the Supreme Court.
That is a different matter.
But either these petitioners, this category of these teachers, they have filed the application before the Supreme Court.
You are confusing now.
I am not confused. Sorry, if I am confused, I am very sorry.
I am confused. You are clear.
No, I am just exactly I am saying.
Yes.
Paragraph 47 is clear that 3 months, within the 3 months, they have order
Is to be processed.
process.
Now it has been processed.
Just since the gap is there, I am making time.
Ah.
Within 3 months, we couldn't do it.
Yes.
Correct? Naturally, we learned a batch of contempt petitions were filed against us
Yes.
by this category of person.
Yes.
This batch of category of person filed the contempt application that see you have directed that within 3 months it has to be done. Then it has not yet been done. Then we appeared and asked for time for compliance of the Supreme Court.
That is for conclusion of the fresh recruitment process.
That is for the content. That is the order, Madam Gandhi. Kindly see, take this.
No, give me the date. The orders are. Then I need printouts. I will not see soft copies.
October 2025 in content application.
Is the order there anywhere?
আপনি ফেলে দিন না।
27th of October is the hard copy there?
No,
পড়ে দিন।
Read out.
পড়ুন।
27th October 2020, the petition was called for hearing today. Upon any counsel, the court made the following: learned counseling appearing from the state of West Bengal state and candidate sent back to their former post in terms of the directions of the court in paragraph 47 of the judgment dated October 5, 10th November 2025.
All right.
And within 10 November 2025, the orders of repatriation were issued.
কি করব?
10th of November 2025. Yes.
The lordships have seen that the repatriation orders all are
Issued prior to that. Yes.
Now 10 November 2025, 17 November, the matter has been disposed of. This order has been complied with. That is not, learned counsel of petitioners states that the petitioners have now been permitted to join duty pursuant to the directions of this court in paragraph 47 of the judgment in this transfer. And we are further informed by the learned senior counsel appearing for the state of West Bengal that the seniority and other entitlements of these persons would be preserved, including their eligibility for grant of increments as directed by this court.
All right.
Therefore,
And the next paragraph, in the event the petitioners have any other grievance,
once or issue,
they
they necessarily have to seek redressal thereof by way of independent proceedings in accordance with law.
Before your lordship,
Oh,
Now,
question therefore, is there another issue? Is a new issue or the old issue? If the old issue, chapter is over.
no.
If the new issue, then the chapter is. Now here, the order was passed, repartition orders was passed in October.
yes,
All of
and the teachers were supposed to join immediately.
immediately, they
Right.
have joined, they have not joined.
Yes, they have not joined because they are teachers teaching in classes where examinations are being held.
Yes.
No examinations were held. No examinations were held. In month of October, which examinations have been held?
It
Nothing.
is for you.
Exactly they are saying. This is all from the bar. No examination.
All right, you do not have anything to say. Now the state government or the council, the primary education department, if they choose to extend time for repatriation, you do not have an issue.
No.
You do not have an issue.
I don't have any issue.
Commission, because your part is over.
If your lordship take me that as a officer of the court, I am just trying to assist.
Yes, I have followed it. Now the only thing is to be done if the state government primary department says that yes, they can be repatriated, they can be repatriated. What is the stand of the state?
I will take instruction because some problem is there. Advocate General, I talked about the Advocate General also. Both the class 4 and 5 argue the matter. The repatriate model Advocate General will argue the matter. The clear picture will become.
What, you are not agreeable to allow them to repatriate?
The question is, they have made a choice. When they chose not to join, I have to.
I have understood it.
Yes.
They are job losers,
Yes.
untainted candidates, permitted to be repatriated because they are still in school and they are being given duties of
Madhyamik and high school.
this. Right now,
No Madhyamik.
if showing some mercy, at least they can be repatriated.
I'm extremely grateful.
Not more.
What has fallen from your?
I'm extremely.
Nothing more. Yes, come back.
He wants to say. No, my one thing before your lordship, before your lordship passes.
Sir, 1 minute, sir. Yes, sir. West Bengal primary court. Main of head of council. They have not been made part. Can you make them part?
মাইতে পার্টি আছে আমারটাতে পার্টি আছে
You all have got conflicting stand. The primary board and the commission will have the respondent number 2, please check up. Directorate of State Education, Government of West Bengal, primary branch is already a party. Let the stand be taken.
প্রাইমারি ব্রাঞ্চ পার্টি আছে
Do not mix up because you all have conflicting interests.
Before your lordship passes.
I do not know whether everybody has been issued the letter of repatriation or not.
Very well, very well. Kindly seize once, because I expected my learned friend for the state at least to be fair to your lordship. Kindly seize item number 5 once. I'll take your lordship 30 seconds time.
The state has not made any submissions, sir, today.
My lord, he said that they have already chosen. They have made the choice. Now they cannot do anything. Lordship, kindly seize page number item number 5 once.
Yes.
Only once. Yes, of course.
All right.
I could have said this before your lordship.
You listen what is submission so that you can revert with proper instruction. Yes.
Lordship has seen already page number 50. Lordship has already seen my lord, page number 55.
Next Wednesday? All right. Yes.
So my lord,
Wait 1 minute.
so my lord, lordship has seen my page number 55 in item number 5. My lord, lordship has seen this is the letter in which we are supposed to join in 30 days. They said that since we did not, so I have already chosen not to join. Kindly my lord turns, lordship has seen it is Sriporna Chaudhary. So my lord, kindly turns page number 60 once, 60. So then your lordship sees this is the order of 13th of November 2025. Then my lord kindly sees what happens here. The Sriporna Chaudhary.
Extended till 31st of December. Yes.
So now,
Even then you did not join.
I tell you lordship, in this meantime, I made the prayer for extension.
Further extension.
Yes. So
How many
tell you, Lord, I'm sorry,
select
Madam.
chances will you take?
I'm just trying to take your lordship to that. Before 31st of December, I tried to, my lord, take an chance for extension of the time. Because as Malani Senior Malad already pointed out your lordship that this was an window to those persons, those category of persons. I wanted this window Malad to remain open.
All along.
At least Malad till the selection process is completed.
So,
Let us the lordship understand everything.
and then my lord says, this is why before 31st December, they have extended the time, 29th of December.
The petitioners claim to be the untainted candidates of the 2016 recruitment process. Stop. Prior to joining service in terms of the 2016 recruitment process, the petitioners claim to be engaged with other departments and autonomous bodies of the state. Stop. Relying on paragraph 47 of the judgment dated 3rd April 2025, passed by the Honorable Supreme Court in the matter of State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others, the petitioners applied for reversion to their previous place of work. Stop. Their applications were processed and they were issued letter of reversion. Stop. The time period for reverting back to the earlier place of work expired. The petitioners pray for extension of time to join their previous place of posting. Previous work, not place of posting, previous job করে দিন। Paragraph D, according to the petitioners, they were unable to revert to the previous job in view of the observation made by the Honorable Supreme Court on 17th April 2025 in the miscellaneous application number 709 of 2025
we can take a benefit of the Supreme Court.
made by the 2025 wherein the court observed that
Simple কথা করতে হবে unable to the right thing to say.
the service of the assistant teachers not found to be tainted have been permitted to be continued as the students undergoing studies should not suffer on account of lack of teachers and the lapses and failures which have resulted in the order passed by the court. Stop. Paragraph. According to the petitioners, as they were in the midst of the academic session, they were not in a position to join the repatriated posting within the scheduled time period. Stop. Next. The petitioners state that currently some of them are acting as invigilators and examiners of the Madhyamik and the higher secondary examination that is ongoing. Stop. Prayer has been made to extend the period for joining in terms of the order of repatriation. Stop paragraph. Learned Senior Counsel representing the Commission submits that as the Honorable Supreme Court Vide order dated 27th October 2025 passed in contempt petition civil diary number 51889 of 2025 made it clear that all candidates will be repatriated by 10th November 2025. Accordingly, there is no scope for extending the period to join in the repatriated post. Stop. It has been submitted that with a order dated 17 November 2025, the Honorable Supreme Court, Videna, in the order dated, clearly recorded that the candidates have been permitted to join duty in their repatriated posts. And relying on such submission, the contempt proceedings stood closed. Stop paragraph. The learned advocate representing the state seeks accommodation on behalf of the learned advocate general. Stop paragraph. Upon hearing the submission made on behalf of all the parties and on perusal of the orders passed by the Honorable Supreme Court from time to time in the matter of Boishaki Bhattacharya within brackets Supra, and the order passed in the contempt proceeding arising out of the above matter, it appears that the court in order dated 17 November 2025 was pleased to direct that if the petitioners have any other grievance or issue, they would necessarily have to seek redressal thereof by way of independent proceeding in accordance with law. Stop. Here, the petitioners have filed a writ petition seeking extension of time for permitting them to revert to their previous job. Stop paragraph. The Directorate of Directorate of School Education, primary branch, In item number 5, where they've been repatriated by the council.
My lord, repatriation, my lord, is by the
In all respect of all the students.
council
Council.
DPSCs are there.
DPSC is. Acha.
So, my lord, this is why, my lord, there are only few writ petitioners who were repatriated
4.
by a one DPSC. So I
Yes,
only find
council DPSC
Malda.
Malda. Acha. Branch কি দিয়ে শুরু করলাম আচ্ছা is directed to revert with instruction as to whether the petitioners may be permitted to join their previous job relying on the order of repatriation. Keeping in mind that they are untainted candidates, comma, were previously in a different job and their job stood nullified by the order passed by this court, affirmed by the Honorable Supreme Court. Stop. Not permitting the candidates to be repatriated will have a direct effect on their life and livelihood. Stop. The matter is fixed for further hearing on 25th of February. Wednesday, just now it was. Why? Yes, we'll keep it on Wednesday is convenient. 25th.
only one.
Order will go down in the other matter.
Only one request, your lordship, where my lordship has recorded that we have submitted that these persons are invigilators or examiners in the exam, as well as one of these persons are engaged with the elections duty. Can you record this as well? They have
Election duty,
the teachers.
whether you are in this place or your previous place, that is different.
Appointment as election officers will be going otherwise. So
And engaged in election duties.
grateful.
Everybody must be in election duty.
Many of them, not everybody. So as
Most of them rather. The BLOs are the teachers. ঠিক আছে?
this is only why my lord, the commissioner.
আলাদা order হবে।
My lord, this is only why the commissioner has granted the extension. This is only, my lord, why.
Now finished, but that point of time it was there.
Yeah.
Anyway, if some compassion can be shown, yes, primary school teacher is also BLO. এটা কি judgment? No, sorry, sir. Thursdays I take up other matters and it will be difficult. That is the reason. Please adjust yourself. এটা কোন এটা? Who handed over this 3rd April? Please take this back. Yes, the compilation is here, so I do not need this.
Now, most of
Next Wednesday.
No,
Again, the other two papers keep there.
only the verification in 9-10 it has not started, and I have a prayer for the interim order. I don't know if Mr. Bandyopadhyay says it's not going to start within 7 days, no difficulty.
What is the issue?
Well, this is the issue.
All right.
I will finish within 15 minutes. Not even 15 minutes.
What is it?
Lordships need not see the brief at the beginning. All the petitioners belong to the orthopedically handicapped persons.
OH category.
Yes. They got the job in 16 as PH, OH, orthopedically handicapped. Pan India, it is known. I have checked up all the recruitment process. OH equals to orthopedically handicapped. Now this relates to 9 and 10, not 11, 12, because in 11, 12 situation was because they filed it post, everything was done. This is very big. Now this time also, we made an application. While we made the applications, we had to see three things. Number one, their advertisement notifications. Number two, the recruitment rule. And the number three is the roster on which basis what is mentioned. The roster which they have followed, if Lordship may straightway kindly see at page 175.
Yes.
Just before that, my lord, if I can just say, under section 34, there has to be 4% of reservation for 4 different categories of the PH. My lord, I will go to that later. Now, this is the process has to be done. This roster is made under a 99. There is a state enactment. Under that, this roster is framed. Kindly see 12th vacancy. This is reserved for the blindness and low vision. Therefore, we cannot apply. That's the orthopedically. Then thereafter 32. This is the only place of ours. That's locomotor disability. But they reserve it. So they make it vertical, which is not permissible under the rule at scheduled caste, SC. And next is 42nd. Because 4 they have to show. That is again, this is for the deaf and hard of hearing. So it's not for the OH. And last is 72. 72. This is for autism, intellectual disability and others. So therefore, so far as we are concerned, who were appointed as
General category.
no, I'm just coming. So we mentioned in the form as PH, OH, orthopedically handicapped. Now, approximate number of vacancies are in 910 is 23,000, which means 4% of the 23,000 becomes, let me go not the 4%, 1%, because I am concerned with only physically handy, orthopedic hand, 230. Now, total number of 230 must be in the cadre who belong to orthopedically handicapped. That's a mandate of the central legislation. That's a must. Now, they have made their own calculations about 196 who should be appointed, that is reserved for the orthopedically handicapped. What they have done is, though we have applied as PHOH, they are treating all of us as general. This is again a second mess up what they did for the SCST. What is the reason? They say, according to us, OH means other handicapped. Then I tried to see, is it there in the advertisement? Answer is no. I saw the rule, is it there in the rule? Answer is no. Then I say, is it the thing in practice anywhere in India? I saw just the opposite. Can you have a look at page 99, NCRT? Last Roman 4.
OH.
This is of 2006. I have seen all of that. BSNL, even the government of India only come to everywhere. This is like there is a central government notification. Page 186 is the relevant portion. .3. The points 1, 26, 51 and 76 of the roster shall be earmarked for persons with bench mark. Therefore, one for the visually challenged, one for the deaf and others, one for the OH. Now, Lordship, kindly have a look this 34. দিয়ে দাও kindly have a look at 34 বার করে দাও
Persons with Disabilities Act আছে আমাদের
like this there.
yes
Kindly see number 34(1). Every appropriate government shall appoint in every government establishment not.
section 34 you are
Yes,
showing
it was opened.
this is rule
No, not the rule. I am saying section 34. Rule I will come later. Oh, তুমি rule দিয়েছো?
section 34 yes
In fact, there is a thing called what is always there in the prejudice in the mind. I told my learned junior, you must be ready with the rule. So he kept that in mind. So irrespective of what I am saying now. Fine. Now 34. Every appropriate government shall appoint in every government establishment not less than 4%. I go by 4%, not even of the total number of vacancies. Kindly mark 23,000 in this case. So to that, in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% kindly mark each shall be reserved for persons with benchmark disabilities under clause A, B and C, and 1% for persons under D, E. Now kindly see, so far as we are concerned, we fall under C. So 34(1)C equals to 1%, that means 230 if I go by total number of vacancies, but I am not on the number. Now under D and E, that is grouped D and E, it has to be 1%. So therefore, it is the mandate. If there is a 100-point roster, that's the mechanism by which this 1% will come. There has to be one clear cut for wage, and it cannot be reserved for like anybody else. Now, can you have a look at rule 11(4)? কোন পেজে আছে? It might be possibly it's at 51 page.
Rule 11(4).
Rule 11(4).
notice of meetings or what
No,
It might be at page 51.
one
Last.
is it the notice of meetings
No.
11(4)
It is 11(4) is the rule, my lord. It starts with the reservation of person. Lakshmi, kindly take the 2017 rule. Where are you gone? What is happening? I don't get it.
দিন আমি বার করে দিচ্ছি।
একটু বার করো।
আমি বার-
Just kindly. Yeah. Why don't you flag it?
yes 11(1)
Can you come straight away? Come to 11(4).
computation of
Yes.
computation of vacancies
11(4).
yes
The reservation for persons with disabilities in accordance with the provision of 34 of the Act shall be horizontal, and the vacancies for persons with benchmark disabilities shall be maintained as a separate class, which means it vertical is, my lord, is a homogeneous, like SC is only for SC. Now horizontal is always mixture of anything. Now they realized they made a, if I can use the word, a complete blunder in doing this. Now what they have done, just in the when the process is going on, kindly straight away page 1, the roster on which basis they are going this recruitment, that was at page 175. I have shown where we don't find our place. Now on 27th of January they come up with a new roster. There, kindly come to 194.
yes
Now I would say now they have learnt, but they have not corrected themselves fully. They have marked. Can you see 12th vacancy? That is correct. That now they have made it unreserved. Unreserved, it is now PWBD. That is a benchmark disability. So anyone, in fact, ideally they should identify which one is for one person for each. Even then, now this time 12, 42, kindly come 42. It is also again benchmark, so all can come. 72, also all can come. But 92, in fact, what was the earlier 32 that which they made? No, earlier 32, earlier roster 32 that
Schedule caste.
yes, now they have taken that to 90. So the good thing what they have done, they have made 3 other, that is 12, 42, 72 horizontal. But they have made 90 as a vertical. They kept it only for the schedule caste.
12, 42, 72 is horizontal.
Yes.
92 has been
90, not 90. 90. 90
SC
is the same mistake which they did. So that's why I said that they have corrected themselves of 75%. Now the prayer that I am seeking before your lordships, based on the historical mistake they did. In 11-12, number of vacancies for them, orthopedic handicap was 103. Because of this, they treated every orthopedically handicapped as general. 100 vacancies remain vacant. Petition filed, but they came later on, so there was no scope for any interim order. Lordship admitted, and they will file an oppositions. Now in 9-10, our name are there in the preliminary list. Now they are checking. They have not declared us a general, but they will do because they have done. Because
an interview has not been taken.
no, it has not done.
Verification.
The interim order I am seeking is this, following their spirit and the honorable courts. Somewhat different mess up they did for SC and STs. So when your lordship passed an order that you cannot treat a SC and ST as a general, that was an individual order. They challenged before the honorable division bench, and the honorable division bench then extended to everyone the benefit, saying that whoever filed the writ petition by 2:30 for some limited time, we are opening the portal, you correct that, and based on that it was done. So all I am praying, I have 2 alternative prayers. First prayer is that our names are the preliminary list. Kindly restrain them not to treat us as general, not to reject our case, which they have done in 11-12. Because we are orthopedically handicapped, we have no scope, we have used the PH. I could have understood that they show that no matter in Pan India, they have a different acronym, but
1 minute. When you put in the your reservation category, there is a drop box.
yes,
What
did I
is
do?
the drop down?
Page 29.
What are the
Yes, page 29.
কিন্তু ফর্মেটটা ছিলই না বলতে এডিট অপশনে
I know. I know. 29.
yes categories?
Category policy PH. Now there is a confusion. One question may be put to me, why I did not go for LD, that is locomotor disability. Reason is that is reserved for SC, and they gave a notification also saying notification ta kothay? They also publicly notified
later on.
clearly saying that this is LD is only for SC, which is their roster itself. This is nothing but saying it publicly that it is for SC, which is already is part of the record that under their 100% roster.
It has been brought to a notice that some candidates are seeking clarification on the category SC PhD, PH,
Yes,
LD.
yes. It is clearly stated that this vacancy is reserved for only SC candidates. So that's what the roster. So it's basically their stand as was in the incorrect roster that they have expressed, nothing else.
আমরা চেয়েছি যে ওই মানেটা কি
I know. In fact, at page, can you have a look at page 95? Either they should give it in the advertisement that wage means maybe a scientific formula, different thing, or they must follow what is everyone understands all of it.
95.
Yes, 95.
It is a letter.
It's a letter. We wanted to know
Yes.
kindly, no, he is not the petitioner. He is one of the orthopedically handicapped persons.
All right.
So now that the notification, can you see the last but one paragraph from the bottom? Now that the notification and online form fill up list, the categories of disabled people as VH, HI, OH, LDSC. Our submission is that OH category is there. What does OH mean? Or which category does the disabled person? What is this? Basically, they wanted to say that where should we feel, go? Orthopedically handicapped persons
Where
who
should
are
we
not
fit in?
SC, what do we do?
Where do we fit?
Yes. Now, we were treated as OH, means orthopedically handicapped, even in earlier recruitment process. As I said, in Pan India, it is also understood by this. Now, in any case, we have dropped that as an OH. Now, for 11, 12, they have whoever orthopedic handicapped persons, whoever applied as PHOH, they have treated them general. Irrespective of the, kindly have a look at their rule. Kindly take page 82.
Yes.
First, kindly take the definition 2R, reserve category. Means a category of reservation in respect of scheduled caste, scheduled tribes, other backward class, and here I come, physically handicapped candidates and other categories of reservations. If any enforced by an order of a competent authority. So therefore, under R, there is no demarcations by them. Thereafter, kindly come to 11 Roman 2. Sorry, before 11, sorry, I should go to 4 also. Kindly come to 4 Roman 5. That is at page 83. This is for the duties under 5 to determine the format of application along with brochure, information relating to filling application form and mode of publication therefore. Kindly come thereafter 9. The form of application for appointment shall be such as may be determined by the Central Commission from time to time, and the mode of submission of such forms shall be, kindly see, exclusively online. Everything with them. Now kindly see 11 Roman 12.
Yes.
This is the situations, our names are there. Thereafter, the regional commission shall verify the credentials and eligibility of the shortlisted candidates appearing for interview vis-a-vis their applications prior to conducting an interview. Applicants whose credentials have been checked and found incorrect by the regional commissions and candidates who are found ineligible to participate in the selection process shall not be allowed to appear for interview. Absence of a candidate during this is not relevant. Kindly see also the next 12. The regional commission during document verification in case of any doubt. Now this is that what they can about the disability level of any physically handicapped candidate may refer the matter to the competent medical authority constituted as per the such and such. Now kindly have a look at their advertisement. That's the notification itself. That under 13B at page 79.
Yes.
They clarified that if a candidate is allowed to appear in the state level selection test, it does not mean that the eligibility of the candidate has been finally verified. All I am trying to say is this: whether I am actually orthopedically handicapped or not, yes, you have the entire right up to counsel. In fact, they can do even counseling time also. But on a technical ground, on a misunderstanding of the law, in a situations where also in Vivek Pariya matter, the Honorable Supreme Court also passed an order protecting to an extent that our candidatures cannot be adversely affected. In a sense that if I am orthopedically handicapped, I was working. Today they cannot say no, you are shut, you should be treated as a general, which they have done for the 11 and 12. That they cannot do. Now, what they are doing, kindly also see their own recruitment rule schedule 89, page 89. There is a ND, right hand side, my lord. For considerations of applications in SC, ST, OBC, PH categories, certificate issued by the competent authorities of only the government of West Bengal. So now if I see the chain of things, the recruitment rule does not say anything about. No, I am seeking an right, but no, I have to
He
because
prays for interim order.
no, that case was after.
There it was at a late stage
Yes,
that they
yes,
came. Right now there is a scope for passing an
That's
interim order.
Now,
Do you admit to an interim order being passed?
what I am asking interim order is this. May I straightway show what I am asking, which I am drawing from the way they have treated when they made a messed up situations. How they created it. Now, kindly have a look at my lord. First, my lord, may I show you first single bench order. Kindly have a look at paragraph 23. I will go to the revision bench, but after showing two paragraphs of your lordship. In SCST, that matter, paragraph 23 and 29, because their appeal, yes, Mr. Bandyopadhyay, they are agreed that we are going to give. It's not that your lordship's order was set aside. That's the reason. 23, the notices of the commission that anybody who fails to update or edit their option shall be treated as general category by paying the application fees meant for reserve category cannot be comprehended. And then kindly see 29, the commission cannot suo motu treat a reserved category candidates as general category candidate despite the candidate's disclosure of being a member of a particular reserved category. So that's the definite order of your lordships. The honorable, which was not set aside, the honorable division bench, kindly take the division bench. Kindly take my lord, paragraph 11. In course of hearing of appeal, we suggested that appellant should open the portal till 6 p.m. tomorrow, that is December such and such, to allow every writ petitioner who filed writ petitions up to 2:30 p.m. today, that is the December 25, to update their categories. Because if they have a software, their internal problems, they want it should go in a particular way. That was allowed. And based on that, their notification. It was exclusively for the other side. Kindly see, this order was restricted to 11 and 12. But what they have done it, kindly see the notification 16/12. After the honorable division bench order, third paragraph. Similarly, following the spirit of the said order, dated 16/12/25, all candidates of 9-10 who file their application form by paying such and such are also given a final opportunity to edit the categories. So my respectful submission before your lordship is this: 230 is the 1% of the total number of vacancy. Now,
Did you apply in terms of this order?
no, they have. This is in this case. This is for the SC/ST only.
SCST.
It is nothing to do. I'm seeking the similar way. There are two ways. One, protection I'm seeking. Lordships can restrict it that
They can proceed with the verifications, but they cannot treat us as a general and reject our case, subject to result of whatever finally decided by your lordships. This is one prayer. But other way, as their spirit and the honorable division bench was that it is some difficulty, some technical
You
aspects.
want them to open a window so that you can rectify
Maybe
your-
yes, give it in the publications for 24 hours. If they wanted that, no, because what they want we should have done it PH. It should be locomotor disability, but
LD.
now that LD on that day roster it was only for SC. Today the new roster has come because the government have realized that that's a mistake they have made. So now there are 3 points. Kindly have a look at the roster.
How are they trying to fit in the new roster with the earlier recruitment notice?
There roster is, may I show, roster is made. In fact, it's a lordship in fact put a very relevant legal questions. These rosters are 99 Act are created under a state act after 1999, which banks on the relevant parent act of the reservations. Kindly take. But this is the West Bengal regulation of, it's a long, I'm not reading entirely. Kindly straightway come to section 14.
Yes.
The roster begins with under this act. 14.
Yes.
14. The state government may by notification prescribe model roster for recruitment to post in government establishment or establishment of public entities, statutory bodies, government companies, local authorities in order to ensure that vacancies in such posts are filled up. Kindly see, in accordance with the provisions of this act and any other law for the time being in force providing for reservation for any class or category of persons specified therein. Therein refers to 34 and each. And also kindly see 9, section 9. That refers to the physically handicapped persons. In order to enable the appointing authority to fulfill the requirements of the persons with disabilities, 90, because earlier it was the 95 Act, now it's 16. The employment exchange concern shall forward to the appointing authority a list of registrants being persons with disability for each post reserved for them in terms of the provisions of, kindly see, is chapter 6 of the said act. So now this chapter 6 now comes to 34 of the 16 Act and the rules made thereunder. It shall be the responsibility of the appointing authority to mention in the requisition in the number of posts reserved for such candidates to enable the employment. So the mechanism is this: 34 requires 1% for each. In other words, 34 requires 1% for wage. Now 34 has to be implemented in a mechanisms under 99. But 99
Yes. Just wait.
yes, my lord.
Yes, continue.
Yes. No, I don't do that because there is a suffering that I am
Yes,
seeking
then-
an interim order. That's the reason.
Yes. Yes, please.
Whatever the- we are
Do
on
not.
camera. What you are
All
doing-
this can go on outside the court, please. Yes.
Okay.
Hmm.
Okay. I don't want to play the game in your game.
Please.
I would be
Please do not make any comments. Yes. Hmm.
okay.
Yes, please.
Yes. Then, my lord, my lord, the central legislation requires 1%, which is equivalent to around 230, but here they have made it 196, but I'm fine with that. 196 for the.
All right, more or less I've understood. Let me
So-
hear.
But today, my interim order I'm seeking two.
All right.
Yes. Well, I have already. These are my respective.
Yes,
submissions.
please. Hmm. Which roster? Is it page 174? There is another roster, but page 194.
I'm seeking benefits.
Hmm. 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 27th of January 26.
Oh,
Yes, yes, that is very settled. Hmm. Hmm. Hundred and? Yes. Yes.
not which. Please give that to which have. Oh,
Hmm.
I'm kind of 120. This case not in the which.
No, no, you say OH is other handicap.
Other handicap.
All right.
Which is other handicap.
Where will a candidate get to know that OH is other handicap? Because there are other recruitment processes where OH is treated as the orthopedically handicapped. Yes. 19 June 2025. Hmm.
And following the
Hmm. This is for SC. Suppose this candidate won. A general category candidate with locomotor disability, where will he go?
No, that general candidate locomotive. What is law? 1% has the law that 1%, but half percent.
The act says so.
1%.
Yes.
1% for SC.
Where from are you inserting SC over there?
1%.
1%, it includes all, in everybody.
Out of 1%, SC, ST,
Everybody.
everybody is there. 1% SC, 1%.
Where from is this SC coming?
But SC is coming from that. Is
Where?
That is according to roster.
Whether the roster.
If the roster is not challenged, that is accepted. That's exactly my argument. The roster is not challenged. You have to go by the roster. Otherwise, your roster has to declare roster is illegal. The way your roster is.
No, but then right now your submission was that 1%, it includes everybody. In general, as well as the SC, STs and whoever. Right. But
They
the,
are horizontal, vertical have been kept together.
here,
Horizontal, vertical is a general case. When we read horizontal. But when it's specific, the act has come.
hmm. Yes,
After 2006, it has been made SC. Earlier it was not SC. Therefore, SC has been made. Within the SC, there is a candidate.
and general cannot be fitted.
General cannot be.
Where will the general go? Where will the reservation? No, no, the law says so. The act is says 1%.
Yes.
It includes everybody. And you have the roster says it is only the scheduled castes.
Yes.
Where will the general candidates go?
General candidate is open the roster is not there, not there.
And that is illegal.
But it is illegal, then the challenge has to be made.
Assuming the challenge is not there.
No.
But it is something which is palpably illegal according to you also.
Not a- That's the comment. Roster,
Central government,
recruitment organization,
96.
yes. Go to the National Council of Education, Matrix Organization for Development of Education. Also has got it. And another material can come to the clause 9. Number 9. Go to the extreme right hand side. Right come. ST reservation. ST dash PH.
Visually handicapped.
OBC HH.
Hmm.
There were categorization of the student classes by OBC. There.
See, the acronyms are mentioned in page 99. VH is visually handicapped. OH is orthopedically handicapped.
No, therefore SC cannot only has to be done in general cases, not curricular according to my submission.
Whether OH, as there are several advertisements where OH has been treated as orthopedically handicapped.
Yes, and next come AB 17 OBC 18.
Do not go to those specific points. It's OH or LD. This is the issue. OH or LD.
Correct.
Right?
OH or LD.
OH or LD.
LD. Now, what is his certificate?
His certificate.
Certificate. Am I talking?
Do you all have LD in the drop down boxes?
Yes. It is there. It is there.
LD is there.
Yes.
LDSC. Drop down is clear.
Yes.
SC. That's great.
That is only for the SCs.
Doctor.
Where roster is different. Roster we come later on. Where will an orthopedically handicapped category fill in his application form? Then where will OH go?
If vacancies are not there, what can we? I go by the roster.
No, vacancy is different. Vacancy point is different. A candidate has to fit in his application first. First, for applying in a recruitment process, first step is application in the recruitment form.
That is
You, it is your part because you make the application form.
Vacancies come here.
Go to the vacancy later on.
Is coming from with the roster. With the roster. I cannot change the roster. With the roster. Never do. The moment
One maybe make an application. Giving a certificate of a locomotive disability, whatever it may be. His claim is on the basis of the certificate. Whatever he is saying in the application form, it is not sacrosanct.
This is your form.
No, what he is saying in the application form, it is not sacrosanct. His details, whatever he is filling up, I am telling that.
All right.
This is subject to scrutiny. And at the time of the scrutiny, he is giving this certificate. LD certificate.
Till now you have not scrutinized. It is
Why-
at this stage.
Very nice. This is the document he has annexed. I have not annexed. This is his document. So on the basis of this document, where is the scope? You will not create another document. I hope so.
That means in the application form that you have floated for recruitment, there is no scope to fill up an orthopedically handicapped category, general category candidate.
There is no form, that is, your lordship is correct. There is no, in that place, there is no scope to do it.
No scope to do it.
That is, your lordship is absolutely
All
correct.
right. In that case, what you are doing is you are treating a physically handicapped category candidate in a reserved category. Can you do that?
Yes, on the basis of the roster.
That means you are not allowing reservation to a reserved category candidate.
I am allowing a reserved candidate, scheduled caste, SC,
Scheduled
that is
caste
also
is-
reserved category.
Scheduled caste is you
Scheduled
are
caste-
allowing, but
Not-
general you are not.
No, there is no scope to do it.
There is no scope to do.
There is no scope to do it.
Vacancy.
Now, Milad,
Vacancy.
Yes.
kindly see the vacancy.
একটু দেখিয়ে দিন না
কোনটা?
তো দেখিয়ে দিন তো সাথে ডিসপ্লে করে দিচ্ছি
No, kindly, I am displaying this.
ভ্যাকেন্সি আমার কাছে যদি না থাকে আমি কি করে করব এখানে জেনারেল এলডি নেই তো যে কোনো পেজ
Milad, take one Bengali grade.
Bengali?
Grade, kindly see from this display. Display.
নেবেন না
See, you are 880, male, female, female, 330.
Yes.
ST 122, 46. SC 439, 166. OBCA 209, 78.
Which one you are reading?
Not Bengali grade, assistant teachers.
ফার্স্ট পেজ
First page. We'll give the affidavits. We'll give the affidavits.
Yes.
Lots of got it. Milad?
Hmm.
Now see, you are 880, male, female, then female is 330. 330 reserve. ST 122, then 42, 46. Then SC 439, 166. OBCA 209, 78. OBCB 146, 55. UR PH BH 21, 8. UR PH HI 21, 8. UR PH OH 21, 8. SC PH LD 21, 8. EWS 210, 79. Bengali 2090, 786. If it is not there,
This is the vacancy statement.
yes, vacancy statement, I cannot go beyond that, my lord. That is also under the act.
Is it?
Vacancy, I have to accept. Process is this, the vacancies would be informed to us. Vacancy position will be given to us. Advertisement will be, we are the facilitator rather, that to This has been given to us. That this has not been challenged by any point of time. And my lord, kindly see, just take this 2025 months, kindly see. Paragraph 90. Kindly read below paragraph 90. It is no longer integer that the terms of an advertisement issued in connection with the selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 of the Constitution or, for that matter, Article 14. Once an advertisement is issued inviting application for public employment, it is a responsibility, nay, duty of an aspirant to read and note the terms and understand and what its requirements are. If any aspirant finds any of the terms ambiguous and there is scope for an inquiry inbuilt in the advertisement or is provided by any rule regulation, an effort was to be first made to obtain clarity for understanding the requirements accurately. If no such scope is available, nothing prevents the aspirant from seeking clarity by making a representation. Should each clarity be not provided, the aspirants may participate in the process without prejudice. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding of the disputed term, his own understanding, we are not messing up, own understanding, or it would not be open to him to challenge the selection on the ground that the disputed terms is capable of being entertained such plea of ambiguity while preferring to accept the recruiting authorities' understanding of the said term. This is for the simple reason that the recruiting authority is the best judge of what its requirements are, and it is such understanding of the recruiting authority that would matter most on cases brought up before the court. Hence, after the commencement of the process, when aspirants have participated without raising any demur as to what a particular term means, even if any of the terms be ambiguous, as the court should deal in favor of the recruiting authority. Now, roster is a public document. Roster is a public document. You didn't challenge the roster at that point of time. They should have come before the selection process, even after filing of the application. Now, at this stage, how it can be entertained? Roster is a public document. And I cannot go beyond this. Now, my lord, kindly see the.
For the state in this.
My lord, kindly, Mr. Vivek,
Are you there?
Just, I will finish it, my lord. Just kindly see the second notification. He is asking for the relief in the line. I hope he has messed up his client. See the notification, all that.
194.
Page 194. Right? My lord, kindly come to the notes. Kindly come. There I will not give you clauses table. Clause 2. The governor is also pleased to direct that a reservation for persons and with disabilities as provided under subsection of section 34 of the Right of Persons with Disabilities Act 2016 shall be implemented as follows. A. 4 roster points reserved for the PWBDs in the model 100-point roster will be genetic in nature and hence not earmarked disability category wise. Disability category wise allocation will be determined only at the stage of recruitment based on actual appointments and maintenance of disability category wise register in every government establishment. B. This detailed guidelines regarding implementation of reservation persons with benchmark for distribution disabilities for the service and post under the governor of the West Bengal, government of West Bengal in the model 100-point roster of vacancies and maintenance of a duplicate disability category wise register in every government establishment will be published by the Department of Women and Child Welfare, so and so, so and so, so and so. Now, this is at the time when the process of recruitment is started.
At the time of credential verification, will you give them an opportunity to show their LD, OH, whatever?
The question doesn't come now.
Right.
Question, according to us, the question doesn't come.
Right.
Now, he has relied upon your lordship's order.
Where?
27th, which went to appeal court earlier.
SC.
SC. SC. Now see the division bench order. There was a tough contest of the matter. Now, that time,
And that time you accepted to open a window.
kindly just read this, read this, please. Paragraph 11. In course of hearing of the appeal, we suggested that appellants should open the portal till 6 p.m. tomorrow, that is December 17, 2025, to allow every writ petitioner who filed writ petition up to 235 to answer. Learned senior appearing for the appellant submits, the appellants are agreeable to do so. But during the course of hearing, court has suggested that
And you accepted it.
Yes, accepted. That's correct. It is not that I am not accepted. And my luck is this. Unfortunately, wherever I have given a concession, that is taken as a right. Sometimes I wish to be very liberal, and I am a liberal person. Now court pressure and others pressure, I would not be liberal in future. And some persons, not Mr. Dot, some persons takes it under the pressure of the court, it has been done. Go and give fight.
Nothing of that sort.
No, I am telling to your lordship, since your lordship has said that you have given the consent.
Not concession, it is
concession.
You have agreed to the.
Yes, suggestion. Yes. Otherwise, court has understood what is the argument I had made.
Yes.
Now for 20, and this is only for the civil caste civil type.
Only
and long back.
Long back.
It has been long back. Now, Milord, kindly see the notification, 16 December 2025. The notification, he has given the notification.
Yes.
Kindly see, writ petition should have been filed. One of the condition was there. That time writ petition was not filed.
No, this is for SCs.
Kindly see. Come to last part, one paragraph. Failure to their respective categories within the stipulated time as indicated in the said solemn order.
No, who is going to whom this public notice applies?
Including PH.
SCPH.
No, ST stroke PH. Can you read it?
যারা 200 টাকা দিয়ে ফর্ম ফিল আপ করেছে আমরা 9 10 এর জন্য সবাইকে রুলস দিলাম
and kindly see before that, similarly following the spirit of the said order of 16 December, all candidates of class 9 and 10, we have not restricted class 9 and 10 so far pending writ petition is concerned. They are class 9 and 10. Now, similarly, following the spirit of the said order, all candidates of class 9 and 10 who file their application forms by paying an application fee of 2 are also given a final opportunity to edit their categories SC, ST, PH up to 8:30 p.m. on 17th December. Now, this chance was also given to them. They have not responded.
Where will they fit?
Ultimately, falls down to the same question. Since options argument has been made, that's the reason I am arguing. Otherwise, I would not have argued.
No, where will they fit?
No, there is no scope.
No scope. That means they have to be treated as general.
We are treating them as a general. They should have been cancelled because 200 rupees has been given.
Because they are physically handicapped.
Physically handicapped. Now we are not. It is not a we are treating them as general candidate.
That is your problem.
Not my problem. The problem has been created by the roster, and that was open, is a public document which was not challenged at any point of time.
Alright, I follow.
And after the selection has started, after participating in this selection, one cannot challenge. There are number of judgments are there. I can cite to your lordship. So.
I was just
And I will be submitting that I want to file an affidavit. And kindly, beloved, do not interfere with the selection process now. Do not pass any interim order.
all right. Just 3 sentences. Page 74, there advertisement.
I will hear you because state will be required. I just want to know prior to you starting What prompted you to come up with
Can
this
I,
que-
can we just stick?
What prompted? Go, you can also
See,
go.
one thing, my lord, before your lordship, my lord, had a puts a query on the state, my lord. That very question, my lord, I am in item number 7, my lord. These 20 roster, my lord, previous roster, 32nd roster was challenged by me.
Hmm.
And it was previously heard by your lordship. Thereafter, it is being heard by a coordinate bench. There, my lord, the bench was of the opinion that prima facie this is incorrect. Horizontal reservation cuts across vertical reservation, so it is incorrect. During pendency of that, my lord, the state comes up with this new roster in supersession of the earlier roster. Now, my lord, presently, because of that writ petition, my lord, the new roster has come up. My lord, yes, I can.
You are not that.
No, I have the documents, my lord. I have the documents. I can show that, my lord. Secondly, my lord, at this present time,
You
the
can leave. Because it's already 2 o'clock will start. You can leave.
Time আছে
Continue.
1 minute time আছে to be contested
32nd roster
Hmm.
is now not in existence. Now the new roster has come up. What we want, my lord, now the recruitment will be governed by the new roster.
Why will the old one not be there?
It is the new roster has been framed, my lord, in supersession of the earlier roster.
Yes, show me that.
Yes, my lord, it is written, my lord. Your lordship is item number
After recess.
My lord, your
Cannot
lordship is
say.
in item number
It is
6. I am
you
showing some.
who all are making submission. The court is not making submission.
15 minutes, let's
Please go.
all of us have lunch.
Please go. Please go. Your turn is over. The commission has made submissions. You can leave now.
Page 198.
Yes.
Of item number 6, my lord, I am showing some.
198.
198, serial number 11.
If your lordship kindly says that.
Yes.
In fact, well, at that I was kindly see 74.
Oh, 1 minute.
Yeah,
Let
yeah.
him make
My lord,
submission.
since in serial number 11 it is stated that in supersession of the earlier one, my lord, this has come into effect. Now, my lord, the SSC cannot rely upon the old one in the new recruitment. So what we want, my lord, we are not saying that we have filled up as OH. Now what we did, my lord, has been superseded by this one. According to this, my lord, we can apply as physically and person with benchmark disability. There is no OH, there is no LD, there is no VI, nothing. According to the new roster, there are 3 points where we can apply under the heading person with benchmark disability. Since the commission the state has brought a new roster, my lord. According to the new roster, we are entitled to edit our application with person with benchmark disability because the earlier roster has been superseded.
All right. But this supersession will be effective on and from the date of the notification. You
My
cannot
lord,
say that it will have retrospective
to this, my
effect.
lord, the new roster, earlier roster, the 32nd roster, your lordship knows, advertisement was published on 30th of May. So, my lord, the roster which was in prevalent before 30th of May would have been followed. That roster was also followed from 13th of June 2025 after the advertisement came into force. Kindly see the old roster of 32nd. Item number 6, my lord, get to page number. My lord, page 173.
13th of June. 13th of June?
Yes, my lord.
Yes. This
So
is
the advertisement was published on 30th
30th
of May?
of May. Yes.
Yes, amendment may have been made. Kindly see. My lord,
1 minute. No parallel arguments, please. Yes.
my lord, so my lord, amendment, it's correct. Amendment was in 2019, but it was incorporated in the new roster in 2008 on 13th of June 2025. But the advertisement was published on 30th of May 2025. So it was after the advertisement which was incorporated. Now in the
Prior to this 13th of June, which roster was being
well,
followed?
that was roster of 2000 subject, most probably of 2019 or 2012, which does not, well, it was It was prior to 2016 because the 2016 after the PWD Act came into force, the new roster was amended only in 2019. Prior to that, the 2012 roster
Page 169,
was in existence, my lord.
169, 2011.
2011
Yes,
roster.
that is there.
That was
But that was prior to the act coming into force.
That was unreserved.
After the act came into force,
roster
173, first roster is 13th of June 2025.
my lord, the first.
In the meantime, the recruitment processes which were conducted, was it in accordance with the 2011 recruitment?
No, my lord. After 2011, another roster came in 2019.
2019.
And the new roster, 32nd roster was incorporated, changing the OBC vacancy status, my lord, also.
All right. I just want to know from the state what prompted you to come up with this 27th of January by making the corrections only in the physically handicapped category.
But I must admit to your lordship that it is your argument which I am taking on before your ladyship of the group. Why I tell your ladyship? Because going back on the same arguments made by Mr. Bhai, but not in the same light as I want to show you before your ladyship. The prayers have not been placed before your ladyship. The pleadings have not been placed before your ladyship. The case of the petitioners is that they did not know what OH mean, right? Kindly takes up item number 7 because I am ready with that. Item number 7's petition, or if I may read paragraph 10 from that.
They say that they thought OH is orthopedically handicapped.
And yes. So say I am OBC. I know I am OBC. So I need to know what OBC means, right? If I do not know what OBC means, I will not go and apply for SC or ST. At the same time, they know what they are LD, locomotor disability. They, by the notification which has already been handed to your ladyship, know that what LD means, right? So there is no place of confusion at all. Number one. So if that is a mistake on their part, applying for OH. Number one. Number two is, they now say that this LD, and that is also probably passing through.
Now you do not take up the stand of the commission.
No, that is
I
not.
just want to know what prompted you to come up with
I'm coming.
27th of January 26.
That is what I was telling.
Yes.
That SC, LD, their case, why I am saying that I am being called on to answer a different case altogether. Their case is that this SC, LD.
Forget what their case is. You say what is your case. What prompted you to come up with this notification?
This is the case which I am being called on to answer before your ladyship out of the blue. It does not concern with this whole petition.
Yes.
There is a query of the court.
I will come back with the instructions on that.
You have come up with this 27th of
Yes,
January.
I will come back with the instructions on that.
13th of June 2025.
Yes.
What prompted you?
I will have to come back on the instructions with that.
Right, then that is all right.
But before that, may I even I
kindly see my
if I can place my case in my own way once.
7.
Prayer C, my lord, item 7.
Item 7.
My lord, may I read? You don't.
All right.
May I place my case in my own way once.
Or in the nature of mandamus, commending the to consider the candidature of the petitioner under 3% horizontal reservation quota for unreserved person with unreserved person with benchmark disability as per the new notification dated 27/1/2026. So, my lord, my specific prayer is this.
So may I place my case once at least in my own way, just once.
On the next day, because this is the query of the court. You are not as such a necessary party over here.
Yes, yes.
It is only the vacancy notification, the roster rather, which is creating a little bit of problem.
I understand, Lord, why your ladyship has asked this question. I get.
Yes. So these candidates, they claim to be of general category and they are physically handicapped. Where should they be given the benefit? This is only thing.
Yes, let us presume on the basis, just 1 minute if I may get. Let us presume on, or proceed on the basis that it was completely wrong. Completely wrong, not giving them a chance to be fitted. You are LD. That is what I understand. You are PHLD. There is no scope for them to participate as you are PHLD. So they are left to participate as simply you are, right?
As general.
You are unreserved category candidates. Let's say that it is completely wrong.
When do they challenge it?
Yes.
Before participation. Once they participate without raising any demur, they cannot now turn back and challenge it. Number one. Number two is that to at such a belated stage after completion of everything.
No, here it is not completion.
No,
That's the reason. Other matter, the court did not
Yes,
interfere.
yes.
It had proceeded to some
But
extent.
on this,
Here, it has not proceeded
Yes.
to that extent.
but that portion your ladyship may kindly be pleased to consider. One second, please just portion of my argument your ladyship may be pleased to consider that there was no question or no place of any confusion. Number one, they knew what SC means, they knew what PH means, they knew what LD means, they have also the certificate of LD. In fact, in paragraph 10, they say that they were previously OH, now they are LD. They have known this throughout. There is no question of any confusion. Number one. Number two is if they say that not providing any reservation for UR, PH, LD is bad in law, they should have had challenged that at the very beginning without any challenge or raising any demur. Once they participate, that too on a misdeclaration, I am ready to accept that it is a mistake on their part, but they are ousted quite rightly and they cannot now turn back and challenge. Number two. Number three is as far as the roster is concerned, the applicable roster, they have not challenged it then, they have not challenged it now. So even at this belated stage, without a challenge to that roster, they cannot seek to sustain this writ petition before your ladyships.
My lord, your lordship has seen that drop box that is.
Yes, yes.
One begins OH.
Yes.
My lord, there is nothing. All this PWD reservation in terms of this 2016 Act, they cannot go beyond this. According to the 2016 Act, there is nothing called OH, other handicap, nothing. So, my lord, a man of reasonable prudence, I initially had a certificate. After this 2016 Act, orthopedically handicapped and now being known as locomotor disability. I found that in the drop box it is OH. Any man of reasonable prudence should think that OH stands for orthopedically handicapped, provided if there is other connotation of OH under the PWD Act. If your lordship kindly see section 34, there is nothing of that sort that OH connotes other handicap.
One small thing, the very advertisement at page 74, kindly take 74.
Yes.
It begins with.
Yes.
So this is not a simplicity advertisement. In terms of the judgment of the Honorable Supreme Court, it begins with that. Now, the Boishaki judgment, paragraph 49, it clearly says they cannot oust us. 49. Can you take paragraph 49? In fact, they are supposed to give concession. 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Now, others are not necessary. Now, coupled with this, Vivek Pariya 20, kindly see this one, 26/11/25.
It will not adversely affect your
Yes,
case.
how they can oust us?
Rules are not infringing.
By virtue of the main judgment, being a part of the advertisement, and I got the job as OH. Now, by this technical, these, that, how they can oust us?
The rules have not been changed. The roster, this is a question of roster. I'm very sorry to interfere, but the rules have not been changed to their detriment. The roster has been.
Law, the Honorable Supreme Court judgment, you cannot oust me, you cannot treat me general.
Yes. Ladyship, I will not.
You have your earlier certificate where it was mentioned as orthopedically handicapped, now changed to.
That is the admission also. Paragraph
I
10.
can bring that, it is not there. It is.
But you had it.
Yes, yes.
Wait.
My last job, in fact, there was this was
Annexed.
This was my
Last job.
incidental. It's a coincidence that the petition number 1, there was an order by your office, and thereafter, one should not be like a scientist in a laboratory trying to find out.
Compliance of such and such. That in the petitioner was a waitlisted candidate. PHOH. In order to comply, writ petitioner allowed 1 mark and came under the zone of consideration.
95.
And this OH is orthopedically handicapped.
I say that physically handicapped persons I got the job
12 এর জন্য এটা
by virtue of the Honorable Supreme Court's order. Even if 34 is not there, my lord, they cannot treat me suddenly as a general.
এটা কত 19 11 class. Lord, I will not make any further submission, but it is my duty to point out to your ladyship, Lord. In 11-12, similar challenges were made. I draw your ladyship's attention to paragraph 9 only for the purpose of interim orders.
11-12, this new roster needs admission. That
But-
was not even there.
No. Let me at least place my case. Paragraph 9, the primary reason by the court is that without challenging the roster, this challenge could not be sustained, sir. Immediately.
Simple.
No. By the coordinate bench. By the coordinate bench.
In fact,
I will not elaborate on this. This is just for your ladyship's assistance, my lord. That is all. And another thing, I am not in 6, my lord. I am in 7. I would be saying.
6, somebody must be
Yes,
there.
he is there. He is there. He is there.
Please come. I think
all our names there in the preliminary interview.
the petitioners. Item number. The petitioners claim to be physically handicapped category, category candidates with benchmark disabilities. Hyphen দিয়ে locomotor disability. They were initially issued the reservation certificate by mentioning that they were orthopedically handicapped. After the implementation of the Rights of Persons with Disabilities Act, 2016, they have been issued reservation certificate by mentioning that they have locomotor disability. The petitioners participated in the recruitment process conducted by the West Bengal Central School Service Commission -SLST 2025. They filled in the application form by disclosing their category PH-OH and paid the application fees meant for reserved category candidates. They are aggrieved as their candidature has been treated as general, that is unreserved category. Stop paragraph. Submission of the petitioners is that there was no scope and or opportunity for the petitioners to disclose their nature of handicap as a nature of disability in the application form. The reservation for the orthopedically handicapped or candidates with locomotor disability has only been reserved for the scheduled caste category candidates. Stop. For the unreserved / general category candidate, there was no opportunity to disclose their disability. The petitioners filled in the application form by disclosing their category as সেটা তো বললাম PHOH তো বলে দিয়েছি. It has been submitted that by it has been submitted that if the petitioners are not being provided the reservation in terms of the act, comma, then the same is illegal. Step. The same is also contrary to the judgment passed by the Honorable Supreme Court on 3rd April 2025 in the matter of State of West Bengal versus Boishaki Bhattacharya Chatterjee and others, paragraph 49, wherein the court specifically recorded that the disabled candidates will be allowed to participate in the fresh selection process, comma, if required, comma, with age relaxation and other concessions. Stop. The same is also contrary to the order passed by the Honorable Supreme Court on 29th of November, 26th of November 2025 in the matter of Bibek Paria and others versus State of West Bengal and others, wherein the court directed that the High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection tests to be held afresh, and their candidature cannot be adversely affected by application of the new rules. Stuff. It has been submitted that the Labor Department of the state has published a notification on 27th of January 2026 by disclosing the by publishing the model 100-point roster of vacancies. The commission ought to vacancies. The said notification has been made in suppression of the department's earlier notification dated 13th of June 2025.
Supersession probably, your leadership.
Supersession, not suppression. Supersession. The commission is following the 100-point roster published by the department on 13th of June 2025. Stop. The commission ought to follow the roster which was prevailing on the day of publication of the recruitment notice, and not the one which came in the midst of the recruitment process. Prayer has been made. No, an interim prayer has been made to direct the respondent commission not to treat the candidature of the petitioners as general for the time being. Stop. The submission of the petitioners, submission and prayer of the petitioners is opposed by the respondents. Stop. It has been submitted that the recruitment notice has been published keeping in mind the vacancy statement received by the commission. Stop. There is no vacancy reserved for the general category physically disabled candidates. Stop. The reservation is disabled candidates with locomotor disabilities. Stop. Locomotor disability candidates in the scheduled caste category has only been reserved. Stop. There is no provision for reservation of unreserved physically handicapped locomotor disability candidate. Stop. It has been submitted that the 100-point roster not being challenged, comma, challenged at the initial stage, comma, initial stage or in the instant writ petition, comma, the roster cannot be interfered with by the court. Stop. As there is no provision for reservation in the roster, there is no scope for providing any extra benefit of reservation to the petitioners. Prayer has been made to dismiss the writ petition. No, dismissal aage. Prayer has been made to permit the respondents to file affidavit in the writ petition. Stop. Paragraph. The learned advocates representing the respective parties have placed before the court Section 34 of the Act, which mentions that every appropriate government shall appoint in the government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities, namely blindness and low vision, and locomotor disability, including cerebral palsy, comma, leprosy cured, comma, dwarfism, comma, acid attack victims, and muscular dystrophy. Stop. Rule 11 of the Rights of Persons with Disabilities Rules, 2017 has been placed. The same mentions that for the purpose of computation of vacancies, 4% of the total number of vacancies, including vacancies arising in the identified Rule 11(2) within bracket 2, English 2, mentions that every government establishment shall maintain a vacancy based roster for the purpose of calculation of vacancies for persons with benchmark disabilities in the cadre strength as per the instructions issued by the appropriate government from time to time. Stop. It has been submitted that despite there being provision in the Act for reservation of vacancies for the benchmark disabilities, comma, the candidates having locomotor disability have not been provided with the benefit of reservation. Step next. The paragraph. Admittedly, the roster pursuant to which the recruitment process is being conducted has not been challenged. Stop. Next. The issue is can a candidate with benchmark disability be treated as a general category candidate contrary to the provision of the Act, irrespective of the fact whether the keep it over there only, not irrespective. The sentence ends there. Stop. It has been brought to the notice of the court that the petitioners are participating for recruitment in level in classes 9-10 level. Stop. The preliminary list has been published, but the process of credential verification is yet to be conducted. Stop. Next, the petitioners feature in the list of features in the preliminary list. Stop. As the issue has to be decided upon exchange of affidavits, comma, let affidavit in opposition by the respondents be prepared and circulated within a period of 4 weeks, reply if any within 2 weeks thereafter. Stop. Liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. Stop. As an interim measure, comma, the commission is not as an interim measure. The commission, during the pendency of the writ petition, the commission may proceed with the credential verification and steps further thereto, but the candidature of the petitioner shall not be rejected outright at this stage by treating them as general category candidates. Stop. The fate of the candidature of the petitioners shall abide by the result of the writ petition.
That item number 7,
Same order.
absolutely same, only one difference. Item number 6, they are in-service candidate and we are freshers. But there is.
But then there is hardly any difference whether in service or fresher. It can go on in the same way.
Your lordships add just one sentence. Lordship has referred the rule,
Hmm.
but the rule 11.4 where horizontal has been referred. Lordship has referred 11.2,
11.2.
but 11.4, 11.4 is where it made it compulsory horizontal. Therefore, it can't be reserved for SC.
11.2 আছে 11.4 টাও লিখে নিন। The reservation of persons with disabilities
Horizontal.
in accordance with the provisions of section 34 of the act shall be horizontal, and the vacancies for persons with benchmark disabilities shall be maintained as a separate class.
Deeply obliged.
যেখানে 11.2 টা বললাম সেখানে এটাকে দিয়ে দেবেন। Affidavit of service and the payment of deficit court fees. In item number 7, there is
That I have given, my lord, deficit court fees and affidavit.
Right. Well, deeply obliged.
Deeply obliged.
I was thinking of continuing, but my officers have to be given little bit of respite.
Yes.
Had it been 3:30, I would have continued, but there is no early rising today.
There is a
So I'll come,
intermittent
I'll go and I'll
fasting
come back.
You have to do any fasting. Neither do I.
No, I'm not fasting, I'm drinking water. Vicky. Seven কি হলো? Oh, seven হয়ে গেছিল, 8. Yes.
Before I begin, my lord,
Your Lordship, Mrs. Bhattacharya is appearing for the board in this matter, but we have not received the brief yet. Over telephone, we have been informed.
my lord,
Kindly
board-
make it not today.
board has been served on 13th. So this is the board has been served on 13th.
What is your prayer?
But kindly sees, my lord has heard the case of this petitioner before. He is an approved headmistress.
All right.
Circumstances compelled her to seek transfer. She was initially granted transfer.
Yes.
In course, before implementation of the transfer order, my lord will kindly find my lord's earlier order at page 168. My lord had given leave to challenge the cancellation of the transfer and other orders. Paragraph page 169.
My Lord, kindly make it not today.
1 minute. 169. Yes.
My lord has seen that.
State relies upon instruction.
Paragraph 11. It will be open to the petitioner to initiate fresh proceedings challenging the subsequent cause of action. The subsequent. Let me at least have the decency to permit me to complete.
All right. Issuance of a disciplinary action, these steps were taken. You wanted to challenge. Now, this is the challenge
Yeah,
to the
this is the
disciplinary
challenge.
proceeding.
The grave urgency is, my lord, the circumstances which compelled her to seek transfer was that, in simple words, her life was under threat. That is, my lord, manifested, reflected in the reports of the Director of School Education and DI also. So they are readily, my lord, acceded to a prayer for transfer. Then, my lord, at page 149 is an order which sort of changes the course of action. Page 149 dated 12th December 2025.
Yes.
This is coming from the Deputy Secretary to the Government of West Bengal. Kindly sees, my lord, direction to initiate disciplinary proceedings. Immediately the next day, page 150, but my transfer is kept in abeyance by the, under orders of the President presumably, by the Secretary, West Bengal Board of.
Yes.
And the suspension order is at page 159.
Fifteenth of January, 26.
So there is already a decision to initiate proceedings. The rule contemplates a show cause, a reply to the show cause, consideration of that reply, and then, my lord, application of mind to that reply, and then a decision if it is not satisfactory to initiate. This at the dictate of a third party, the disciplinary authority cannot initiate disciplinary proceedings. This is my first case.
What is the interim relief you have praised?
Interim relief, apart from the stay of the suspension, my lord, a gravely urgent thing is that, my lord, kindly sees the show cause, the frivolous nature of the allegations. Page 165.
All right.
The absence of.
1 minute. This was issued on 15th of January.
Yes.
Today we are on the 17th of February.
Yes.
More than a month has passed.
Events are, my lord, moving day after day. My lord, kindly sees. But
it's a request for adjourning it for a day.
I am seeking for the moment just one simple interim protection.
Yes.
That the headmistress's room be sealed, so that, my lord, the show cause is, my lord, absence of mechanism to distribute sanitary napkins to students. There is no provision for that. Yet we have a dispenser arranged from an NGO that classes are dirty. Now I apprehend that misappropriation of funds will be incorporated.
if they get to the issuance of the charge sheet, my lord is there to.
No,
But the-
misappropriation of fund comes later on.
Yes, the
Right, immediate interim relief.
is the headmistress's room be
Are you ready with the matter today?
No, my lord, I have not.
Brief has not been received.
received on 13th by the client, president of the board. They take their time.
My lord, I have.
Let the headmistress's room be sealed because it contains the 4 almirahs, my lord, where the papers and the cash is there.
Cash is also there.
My lord,
Are you aware as to the amount of cash inside?
It's not,
Not possible.
even for rupees 25 years ago, there was a dismissal order sustained by the Supreme.
So right now you cannot say how much is there.
I have taken instruction, it will be maybe about 10,000 rupees.
All right.
But let it be sealed till my lord hears out the application. Well,
Okay.
not hears out, but at least the prayers for the other interim reliefs.
And who will be responsible for sealing it?
Respondent number 5.
The police has made a party?
Yes, I see Rajarhat. It was well, at her instance, I think, well, that she was rescued. I have a video, my lord, it will send shivers down one's spine. The way a woman is harassed by, they are taken to be guardians, but they are actually rank outsiders.
All right.
But I fear that,
Very well.
yes, that only limited
All
protection.
right. When do we post the matter for hearing?
Whenever it is convenient.
Getting the brief by today evening. Thereafter, any day, your lordship. Lordship remembers, my lord, this petitioner came before your lordship.
I have placed the orders.
26th is a long way. Today we are on 17th. Right. I was thinking of Friday, if in the meantime you can. But then the interim relief which the petitioner is seeking for sealing of the Almara, that has to be.
Well, that is upon the DI, between the DI and the.
No, not the DI. Not the
state
DI.
is
Because,
represented. State is-
because if his allegation is that in the meantime the Almira will be opened and
there are some loose
evidence
vouchers.
may be tampered, then that will be a problem.
I mean, that,
Acha.
that respect, your lordship, DI is the, first they seek help from the DI, your lordship. So
DI has acted at my, contrary to my interest,
Acha, the
flouting orders of the board also.
the petitioner is aggrieved by
he
the
has been suspended also.
That is the
aggrieved
challenge.
by the order of suspension passed by the president, ad hoc committee, West Bengal Board of Secondary Education on 15th of January 2026.
For the instruction today, I got the brief. I never consult with the
Client.
authority. But they already given the notice to the headmistress to hand over the charge. But still today, the room is under lock and key, and the key is the custody of the headmistress.
Absolutely. But one thing, that is the last annexure.
ঠিক আছে? Learned advocate for the petitioner submits that she was serving as the headmistress of this school. Stop. There are certain important and valuable documents and cash inside the Almira.
There are 4 almirahs.
Inside the almiras, which are kept inside the headmistress's room. Headmistress has a separate room.
Yes, the chamber of the headmistress. Yes,
So there is a
separate-
separate room where
Yes.
there is a provision
That
for
room
lock and,
itself is locked and the almirahs are also locked.
and you have the key.
I have the keys.
Acha. Inside the headmistress's room. Stop. The petitioner has put a padlock on the said room. Prayer has been made to direct the inspector in charge of the local police station
Rajarhat.
to seal the room prior to hearing of the instant writ petition. Not prior to, till hearing of the writ petition.
No.
ঠিক আছে?
Transfer cancel.
Learned advocate representing the state and the board seeks time to revert with instruction. Stop. Paragraph. Learned advocate representing the school. Did you file your wakalatnama, school?
No, today I just got.
Please file your wakalatnama. File it. The school submits upon instruction that despite request being made by the president of the managing committee of the school, the petitioner has deliberately not handed over the keys of the headmistress's room.
Well, that letter is annexed. The time given to me for that has not expired. It's dated 11th February and I was given
7 days time.
That is the other ground for urgency.
All right. On a perusal of the notice issued by the school to the petitioner for handing over the
Last page.
Documents to hand over the charge of headmistress, it appears that 7 working days time was allowed to the petitioner. Stop. The said time period is yet to expire. Stop. Paragraph. As the petitioner apprehends that evidences may be tampered if the lock of the headmistress's room is opened in the absence of the petitioner, accordingly, the court thinks it fit to direct the inspector in charge, Rajarhat Police Station, to seal the headmistress's room for the time being. Stop. Learned advocate for the petitioner is directed to communicate this order to the respondent number 5.
But the learned state advocate may also do that.
Is also there. Is also there. The aforesaid order shall also be communicated by the learned advocate representing the state respondents.
Let it be videographed or photographed.
Achha.
Presence of the DI.
Yes.
DI.
And also
Then in my representative of the petitioners.
The respondent number 5. In that case, I can fix up a date when the sealing can be done.
It has to be done today.
Then will you be able to go there? Do you stay there?
Somebody younger than me.
Me,
Sure.
since the petitioner. I am not saying the council.
Petitioner cannot go. Well, petitioner is facing threat to your life over there. I can show
Any
my
of your
daughter.
representative, any of your
Yes, yes.
representative will be there?
Yes.
Achha, the sealing by the inspector in charge shall be done within a period of 24 hours from the date, order from date in the presence of the representative of the district inspector of schools, the representative of the school managing committee and the representative of the petitioner. Stop. The entire process of sealing of the headmistress's room shall be videographed and videographed by the police and be placed before this court as and when called for. Stop. It will also be open for the petitioner and the representative of the school to videograph the process of sealing. ঠিক আছে? Released Friday, I keep it?
No problem.
20th, 20 তারিখ। Monday? All right, 23rd.
One thing, Mala.
Yes, please.
I need leave to correct the presentation form.
What has happened?
It was the learned government pleader who graciously, my lord, accepted a notice with the corrected date. That is why I can address my
Corrected date?
It's 18th over there.
18th of February.
Today is 17th.
It was March 17th, then it was,
At their insistence, of they act very mechanically.
it is there, it was kept that way.
Forwarding letter at 17.
Acha. Leave is granted to the learned advocate on record of the petitioner to correct the
তারপরে তো মানে জিপি নিলেন
presentation form.
and affidavit of salary.
Leave is also granted the advocate of the HRita ফেরত যাবে school
Advance copy লেখা
to file the wakalatnama in the department. Can you file it today in the course of the day, wakalatnama? In the course of the day. Affidavit of service filed in court is taken on record. This order will be put up in the server so that you can communicate. And how will your representative get the information? I do not know.
Representative will be some junior of mine, nobody else.
It will be done, but then you have the on record's phone number. Please coordinate so that somebody from this petitioner's side is present.
At least the learned advocates are there, let whoever advocate of mine goes, let his safety be ensured.
Safety be ensured.
Let Mrs. Koili Bhattacharya represent.
Ms. Bhattacharya is not going over there.
Obliged.
On item number 9, I am appearing for the petitioner. But this writ petition is preferred due to non-payment of area salary for the period of 11/9/12 to 28 February 2018. Lordship may remember yesterday the same application was preferred and it was make a not today due to non-presence of the state advocates. Here, my lord, my joining is page number 14. At page number 14 on 11/9/2012, and subsequently, my lord, I make my representations before the DI and
1 minute. Joining is 12.
12.
And where is your appointment letter?
Appointment is, my lord, page number 13, my lord.
By
At
the
page number 13, 3/9/12, dated
All
3/9/12.
right. And 15 is
And my
2018.
is my approval
Approval is 2018. You did not get salary from?
from the
12
period
to
of 12 to 18, my lord. Area
And when did you make the representation?
the representation is 2024
Before.
by the school itself at page
That matter was taken up yesterday.
yesterday, my lord, 6 similar matters.
Right. Has the order been put up in the server? Not
Order
yet.
is not uploaded, my lord, still till
Not yet.
not yet. But my lord allowed the prayer and in accordance with law directed DI to disburse this
Without any interest, if I am not wrong.
without any interest.
Can you give me the case number?
Yes, please. একটু কেস নাম্বারটা দিদি আমি বলে দিচ্ছি
Then the same order can be passed.
26890 of 25 একটু নামটা লিখে দে পোস্টেটটা লিখে দে
All right. Same order will be passed.
same one. But make it kindly be a time frame because yes, previous order I think there is no time frame.
No time frame,
No,
There was a
just time frame.
There was
Just time frame.
a time frame, your lordship.
isn't it?
Yes, it is. 12 weeks. 12 weeks, your lordship.
6 months only. Why? Why you want 6 months?
এটা আগের